Serial number 3. I'm sorry. Serial number 3. I appear for the respondents. Sole appellant has died in that matter on 16/10/2021. I couldn't hear the court officer calling that matter. Sole appellant has died on 16/10/2021. The appeal itself has abated.
They have filed an application to bring the LRs of the deceased appellant. Deceased respondent. Appellant himself has died.
Appellant has died. Serial number 3. That is writ appeal 40/76.
Sir, how the government in the case filed by the government it could become abated, sir?
My lord, I am referring to writ appeal 46/76 of 2017.
Some wrong number. Serial number 2.
Serial number 2.
2 weeks time has been granted.
Sole appellant has died, my lord, on 16/10/2021. I will furnish the death certificate by tomorrow.
That is 4676 of 2017.
Please, my lord. There is only one appellant. He has died on 16/10/2021. The parties have given me the death certificate.
You are appearing for which respondent?
I appear for respondents 1 to 3. We were the writ petitioners.
Appearing for respondent numbers 1 to 3 submits that the sole appellant.
Please.
Died on
16/10/2021.
Has died on
16/10/2021.
10/2021. And as such, the appeal is abated.
Please.
Other seeks time to place on record the copy of the death certificate.
Please.
The matter on 21st February as prayed.
Please, brother. Grateful.
In the meantime, Valmir counsel for the appellant to verify the same. Yes.
Grateful.
Abid Ahmad.
Now this memo for retirement is filed by whom? Naveed Ahmad. You are appearing for whom? Yes, wait. Then we have to consider this memo for retirement. It is for recalling the order dated 9/10/2019. That was recalled subject to deposit of ₹50,000 in the account of the Karnataka State Legal Services Authority. Then we will dismiss this first. What remains? We will not permit you to retire from the case, sir. We dismiss the application for recall. If you are not complied with it, there ends the matter. Now you cannot seek for permission to retire. The matter was dismissed. You have filed an application for recalling the matter. We will not permit you to retire from the case. Sorry. No, sorry. Missed the matter on 16th February at the request of the learned counsel appearing for the appellant. No further adjournment on that day, sir. Either deposit or we will dismiss it. No.
My lord, appearing for the appellant.
Uh,
My lord, appearing for the appellant, serial number 7.
yes.
My lord, I think
Yes, madam. What is your submission?
my lord, I seek weeks accommodation. I had a small accident, so I had not been able to come to work for 10 days. I will have the needful done.
I
My
have
lord.
week of the request for both parties.
Much
You are also
obliged.
seeking time. Yes.
Much obliged.
I am for the respondent number 4, my lords. They have not served any copy on us, in spite of direction being given by the Honorable Court on last occasion.
JN. Where is Mr. Naveen Jain? Pass over. Where is Mr. Gautam Bharadwaj? Direct counsel, Mr. Gautam Bharadwaj. This time granted to do the needful. Is there any interim order? It is in operation. And it only stands extended till the next date of hearing. Yes. Interim order is in only in writ appeal 606 of 2020 or in both. Or of court officer find out.
My lord, in all the
Whether
cases,
English
my lord, there is
constitutes
an interim
both
order. My
or-
lord. In all the cases, my lord, there is an interim order. My lord. 606.
You are
Yes,
appealing for whom?
I am for appellant, my lord, in the other 2 connected cases, my lord.
Yes, next matter.
254 and 528.
Yes, check mark. Office objections. Mr. Ravindra Reddy. Production is dispensed with at present. Then what is the matter? The only office objections, huh? Remember hearing 28. Yes, serial number 11. Huh? For you. Why you are seeking leave? Was expired. Tanna Shetty. But LRs were not brought on record. When he died, Tanna Shetty. 21/8/2018 ಅಂತ ಬರ್ದಿದ್ದೀರಾ? 21/8/2018. But other appellants, they have not preferred any appeal. No, what about this Ramanna Shetty, Sundar Shetty, Kamala? They have not preferred any appeal. They have preferred. He is also no more. He is also no more. Sundar Shetty, Kamala. What is the matter? What is the matter on merits? Huh? So 2 sets of application you filed. Yes, government advocate. Yes.
After the disposal of the petition and before my lord's filing the rate appeal, he can seek the view of my lord's and come on the pregnancy of the proceedings before the so after I made an application. So there are unless that is cleared, now we cannot clear you. This is the lesson. The rate is affected.
He is seeking for setting aside the abatement also. Yes, correct, sir. But the order is finished at 2 dead persons. So he is seeking for setting aside that abatement. Why you have not brought the LRs of the deceased petitioners at that time? Then why the other petitioners have not filed the appeal then? How many days delay? No, how many days delay in filing the appeal? 237 is condonation of delay in filing. For filing the appeal.
Yes.
But this order is against a dead person.
That's why you must have the application to permit me to come and say, and not something dead person is you can leave and file the application.
You have to seek review before not a single judge. Then
on that day, they are not alive. Proceedings against the petition number 192 cannot order is partially dead person. Now he cannot make 3 and 4 appeal.
what do you say about condonation of delay?
Application itself is not maintained.
No, for this 3 and 4.
3 and 4 case not filed. The original petition.
Condonation of delay application.
Yes, as far as appellate number 3 and 4.
Yes.
On
Yes, we will reject the application, all the application relating to 1 and 2. We will consider the condonation of delay application. What is that? Condonation of delay IA 1 of 2020.
don't have the remaining here. Because I can go to others in the next application.
How can it permit you here now, sir? Where is IA 1 of 2020?
Record should be clear. It's not my objection as but it's very it's not.
You file objections if any.
No, no, so filing appeal, I have no objection.
No, not for that IA 1 of 2020, the other applications.
I'll I don't the legal position. Objection may not be required. Whether it will not be correct on my part, I'll object as such. I'll ascertain what is the legal position of that.
Is the matter by next week at the request of the learned AG. Terminate counsel for both the parties to refer the matter to Bangalore Mediation Center. Parties are directed to appear before Bangalore Mediation Center. 8 February at 3 p.m.
It's because number 13.
My lord, I appear for the respondent, my lord.
13.
My lord, the appeal is already.
It's because
Yes, my lord. Serial number 13.
You're appearing in 13, madam.
Yes, my lord. I appear for respondents, my lord.
You're not audible. Kindly unmute your system.
My lord, it's unmute itself, my lord. My lord,
Whether it is audible, madam?
yes, madam. Am I audible?
Yes.
My lord, I appear for the respondent, my lord. The appeal has already been admitted on 11/7/2018, and there is an interim order of stay. My lord, we have already filed our list of authorities also, my lord. May it be taken next week or so, my lord, for final disposal.
Some rectifications of office objections raised on these memos. You have filed these memos, huh? This memo is filed by you.
No, my lord.
Okay, for appellate.
I
Why is
appeal.
Learned Counsel because what is the office objection?
That to be served on other side. Memos taken on that. Documents to be taken on.
What is the memo?
Certain documents to be taken on record on.
One is for list of authorities, the other one is
To take some documents on record.
do not take allow.
What are the documents?
They have filed some documents that has to be served on you.
Yes, my lord. That has been already served on me, my lord. By the respondent. Yes, my lord. It has been served.
By the appellant.
By the appellant, my lord.
Yes. Then the matter has to be listed for a final disposal.
Yes,
Some
madam.
in preliminary group.
Yes, my lord. The matter pertains to HRA allowance, my lord. I am the employee of the KPCL. From 2000, they have denied me the HRA allowances, my lord.
There is a,
Sorry, my lord.
you are not filed application for vacating the interim order. Yes, none appears for the appellant. This is the matter. 4th week of March.
Obliged.
Yes, I appear for the appellant.
I appear for
By
respondent number
Annexure
2.
G. By Annexure G,
Yes.
the first respondent was informed to pay property tax of 52,73,000. And the first respondent is the auction purchaser, is the transferee. the transferee is liable to pay the property tax according to the provisions of the Act and rules. In the judgment of the Honorable Supreme Court, reported in 1996 Supreme Court 1579, it holds the transferee is liable to pay the property tax. Subsequently, he can recover it from the transferor. Now, here, that question has not gone into by the learned single judge. Whether the transfer is liable to pay or not is not even gone into. The provisions are quoted. But as between transfer and transfer, they said, okay, transfer is liable to pay up to the date of transfer, and transfer is liable to pay after that. Well, the operative portion of that.
Page 19.
May I submit?
Yes,
Para
sir.
15, yes, para 15 of the judgment. That is,
Yes.
annexure.
Para 15 is the petitioner may appear before the respondent.
No.
Sir,
The judgment, my lord, judgment from it starts from page 7. In that, the last button, para 15, the petitioner.
The petitioner may appear before.
Yes. Before that, para 12, what it says is, there is no conflict of law on submission made by the learned counsel for the respondent. The respondent period is entitled to recover the taxes from the owner occupier as land revenue. Yes, it admits, because whatever I said, the transfer is liable to pay, it was accepted. But the question here is the respondent PDO has to determine the extent of liability to pay tax in terms of the fact situation and the contracted evidence placed before it. The exercise has been undertaken by the respondent before issuing the impugned endorsement petition. Therefore, matter diverse will go back to the said authority. Determination afresh of the liability to the present petition in accordance with law. There is no material record against this one. The petition is bona fide action. The petition is accordingly allowed. Is set aside. The petition may appear before the respondent PDO in first instance. A additional every relevant account authority will pass fresh orders in accordance with law about the recovery of property tax from the petitioner to the extent of liability in this regard. Date of confirmation, so and so. The PDO can file his claim before the official liquidator on the provisions of the Company Act 1956. The question regarding the transfer is liable to pay has not been gone into. In para 2 says, yes, we accept the proposition. This is para 2, starting with, there is no conflict in law. When the transfer is liable to pay, why I should go for the official liquidator? The Supreme Court judgment in that is very clear. 1996 Supreme Court 1579. Transfer is also liable to pay to the period prior to the transfer, but he can recover it from the transfer subsequently. Here, the subsequent to this order, the first respondent paid 5 lakhs rupees. Now 47 lakhs rupees, 47 lakhs 28,000 has to be paid now.
Has been paid.
One more thing, my lord, aspect. I am interested in collecting 52 lakhs 73,000, what I claimed in Annex G, property tax. There is no dispute. Even the learned single judge says that there is no dispute regarding the submission made. Question of law.
That is incorrect, my lord. This says no material on record.
And no. Para 12 I read. Para 12 I read. Para 12. There is no competing law on submission made with learned counsel for respondent. The respondent is entitled to recover the taxes from owner occupier as land. That is that.
Para 13 says there is no
material. I'll come
sorry.
Now, I am concerned with the payment of 52 lakhs 73,000. Whether the first respondent pays or second respondent pays, my lord, I am least this one. In Annexure H, may kindly look into. Annexure H, the first one himself, while filing writ petition, is filed. There is an order passed by the court. This application filed by the direction to official liquidator to pay a sum of 34 lakhs.
Official liquidator has been appointed. Which
Yes,
matter official?
Yes, second respondent appears for the official curator.
I appear for official
In
liquidator.
which matter, for who, in which matter official liquidator is appointed?
Uh,
Lord, in this, my lord,
that is what happened. In
Lord,
winding up proceedings, this property was sold.
my lord,
And
may I
first
submit?
respondent-
May I submit, my lord, with permission?
Yes, Mr. Vivekananda. Yes.
Also say, by the honorable company court Mumbai, that the responsibility of funds,
I cannot hear the submission made by the counsel.
deposited they were confirmed that the service not the council conditions of the option. Page 38. Number 14.
You can, for the time being, you can come this side. Yes. Yes.
Class 14, that's only
Is it audible now, Mr.
No,
Commissioner?
not audible.
Little bit nearer, my lord, you should.
now it is.
Ah,
Yes.
Class 14 land is relevant.
ah,
Page 40.
yes.
The purchaser shall be liable to pay taxes, charges, fees, and outgoings in respect of removal and movable from the date of consummation of sale, and that any rate, any taxes, charges, fees, and outgoings used and payable to any authorities till date of sale will be paid out of the sales profits in accordance with the joint by the official liquidator, High Court of Bombay. But sale was confirmed in 2012 that the possession of the property was delivered on 8/3/2012. From that date onwards, that the liability is on the purchaser. Now, from the first respondent purchaser, the panchayat has demanded the tax from 1986-87. We disputed, saying that I am liable to pay only from 2012. And areas of tax will pay tax. Before the official liquidator, Mumbai. They did not tax it to my request, and they did not transfer the car. Therefore, I have this Honorable Court finding that there is a petition. This Honorable Court considered the matter in detail and directed the panchayat to determine the liability of the tax payable by the purchaser and the liability of the tax payable by the official liquidator. Let's pursuant to this direction of this Honorable Court, disposal which I have filed. The panchayat has passed an order. This is an order passed pursuant to the direction of this Honorable Court. That they are returning the tax and the operative portion of the order that ಮುಂದುವರೆದ ಈಗಾಗಲೇ ಪೂರ್ವದರಿಗೆ ಮಾಹಿತಿ ಮಾಡಿರುವುದರಿಂದ ಏರ್ಗಡೆ ಸಂಬಂಧಿಸಿದಂತೆ ಖಾತಾ ವರ್ಗಾವಣೆ ಮಾಡುವ ಮುಂದಿನ ಕ್ರಮ ವಹಿಸಲಾಗುವುದು ಎಂದು ತಿಳಿಯಪಡಿಸಿದೆ. But I paid not the arrears of tax from 2012 on, and they have already opened the khata. Well, I am paying the property tax from 2017 on. But now, according to me, that the requisition rate of it has become inverted. But one more aspect that I would like to bring to your attention is that's December Court.
No, kindly read the second paragraph there. It is order dated 14/9/2017 passed by this Gram Panchayat.
Second paragraph. Second. ಖಾತಾ ವರ್ಗಾವಣೆ ಶುಲ್ಕ 27,68,787 ಬೇಡಲು ಪಂಚಾಯತ್ ಕಾಯ್ದೆ ಯಾವ ಪಂಚಾಯತ್ ಅಧಿಕಾರ ನೀಡಿದೆ ಎಂದು ಕೇಳಿರುತ್ತೇವೆ. ಸದರಿ ಆಕ್ಷೇಪಣೆಯನ್ನು ಪರಿಶೀಲಿಸಿದ ನಂತರ ತಮ್ಮ ಆಕ್ಷೇಪಣೆ ಕಾನೂನು ಪ್ರಕಾರ ಒಪ್ಪುವಂತಹದ್ದಾಗಿದ್ದು ಹಾಗೂ ತಾವು ಮೇಲ್ಕಂಡ ಸ್ವತ್ತನ್ನು ಮುಂಬೈ ಕಂಪನಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನಡೆಸುವ ಸಾರ್ವಜನಿಕ ಹರಾಜಿನಿಂದ ಹಾಗೂ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಮೇಲ್ಕಂಡ ರಿಟರ್ಜಿಯಲ್ಲಿ ಖರೀದಿದಾರನು ಹರಾಜಿನ ಸ್ಥಿರೀಕರಣ ದಿನಾಂಕದಿಂದ ಮಾತ್ರ ತೆರಿಗೆ ಪಾವತಿಸಲು ಬದ್ಧರಾಗಿರುತ್ತಾರೆ ಎಂದು ತಿಳಿಸಿರುವುದರಿಂದ ಈ ಕಚೇರಿಯು ತಮಗೆ ದಿನಾಂಕ 19/7/2022 ಮಧ್ಯದಲ್ಲಿ ಬೇಡಿಕೆ ಇಟ್ಟಿರುವ 27,68,782 ರೂಪಾಯಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾತ್ರ ಸದರಿ not the years of tax. They have also not demanded the transfer fee. Not we raise objection to that also. They have written that the notice with regard to the transfer fee. And they have accepted 14,27,026. And that they open the khata and paying property tax. That's reasonable court that directed the subsidiary of Mumbai High Court to not state as to whether any state process not still remains with the subsidiary. Not the vital
So
aspect.
in Annexure G, what was the claim made?
Next step, the demand was 52,73,758.
I have withdrawn is 2768,782.
Another notice after issuing the direction issued by the Sample Court. That is with regard to the transfer fee. It is not a real. When we raise the objection that you don't have power, then they refuse that notice. And they have confirmed the liability of payment to 40.
Years of tax.
Yes, but one that I would like to that the Sample Court directed the executive of Mumbai High Court to state as to whether with the executive so as to pay the property tax one time. Pay this in page 77. The affidavit filed by the executive of Mumbai. After narrating the entire background, at the paragraph number 30, page 81.
Yes.
That's married. I further say that the dividends will be declared as of the company and companies that maintain the company code to the variety of liquidation expenses, EDF, then the paragraph number 3 workman gives 6 minutes. Then paragraph 14. I further say that at present, some of the funds of 27 lakh or 60,000 do not happen. It is available to the credit of the company liquidation. Response number 1 to the claim the form that the company code was liquidated to be adjudicated and paid as per the provisions of the company code was. I pay the money and it's not the to make it claim before the liquidator. And when they are asking the purchaser to pay the assets, even prior to they purchase any amount of that is.
What is the date of sale?
The date of sale, that's 2000.
1 to January
16/3/2012. 16/3/2012 will be confirmation.
Then what is the issue by the April 2012 not is the auction conducted.
1/3/2012. Confirmation of sale.
The confirmation is very much
16/3/2012.
16/3/2012. Correct possession of the property. It was executed not on the 12/1/2000.
Now the demand is made from which period as per Annexure G?
Up to 2015-16. Up to
From which
2015.
period?
Oh, up to 2015-16. Before that date, just
Arrears.
They have said it is from 86-87.
It's from 86-87.
no, that
Where
is
to
not
get?
that.
From which period you are demanding?
Up to 2015-16, I am demanding.
From which period?
From 1994 to 2015-16.
From
1993-94 to 2015-16. Now, up to the date of sale, after that, 5 lakhs and all, out of this amount, he has paid. Now, 47 lakhs and 20,
14 lakhs he has paid.
no,
not
14,
5 lakhs.
no, that 14 lakhs includes the no, 14 lakhs includes subsequent period. 2015, 16, Antar Kura Bartha, 16, 17, 17, 18, Bartha. No, that is not that. So far, out of this 52 lakhs, only 5 lakhs is paid. Now 47 lakhs is payable.
May I submit, madam?
Then, my lord, according to the Supreme Court judgment, year 1996 Supreme Court 1579.
There
No,
is no
as per the
dispute.
terms and conditions of sale, this liability is only from the date of purchasing it.
Yes,
The liability of the purchaser.
that is in between transfer and transferee. Now, so far as the local authority and the concerned, the judgment of Supreme Court, what it says is, you can recover it from the transferee, then the transferee can recover it from transfer. That is the judgment of Supreme Court, year 1996 Supreme Court 1579.
May I submit, madam?
Kindly wait, sir. Year 1996.
Supreme Court 1579.
For what proposition?
Oh.
What is the proposition laid down by the Honorable
The
Apex Court lady?
proposition laid on is, property tax is payable by the transferee. Then subsequently transferee can recover it from transfer. This is entirely different.
Under which act?
Under
Which act?
Under Delhi Municipal Corporation Act. And in that, similar provisions, that is what the Learned Single said, there is no dispute regarding proposition. The Learned Single just quoted.
Whether the property was, yes, whether the property was purchased in any proceedings.
No.
No.
Whether the property was purchased in auction proceedings.
No.
Now, the proposition here was transfer of land or building liable to pay property tax even for a period prior to transfer.
Yes.
Such liability is not curtailed. 1579.
So according to which provision of the act deals with this? According to you, sir, which provision of the act? Which provision of the act you are referring?
Learning Single Judge
No,
order
which
itself.
provision of the act provides? Which provision of the act? Which act?
My lord, 1999 and Panchayat Raj Act, tax is payable. There is quoted. May Learning Single Judge order may bring to notice. The paragraph.
Page 12, para 6, madam.
Para 9 of the order. The relevant provision of Kannada Panchayat Raj is also quoted below. Section 199. Every company shall in such manner subject to some further where the owner in building has left the Panchayat area or cannot other form, the occupier of such building or land shall be liable for so and so. Rules 12 and 15 of Karnataka Panchayat Raj Act, tax and fees rules. Liable to pay the tax, etc. As owner of any building or land, etc. tax transfers such a building and any person, such owner as well as the transferee shall within 2 months from the date of transfer give notice. As owner of any building or land, etc. tax, that is so and so. As a transfer of ownership building or land, that's rule 12. Occupiers right to recover the tax paid by him. While occupier of any building or land has paid the tax under subsection 2 of section 199 in respect of such building or land, he shall be entitled to be reimbursed by the owner of such building or land. May in addition to that, any other remedy open to so and so. Now, 199(2) also is quoted in the previous.
His Lordship has referred to section 55(1)(g) of the Transfer of Property Act.
Yes,
The
yes.
interpretation given by the Honorable Apex Court Vijayendra Das.
Yes, yes.
Ah.
That the
There
question
it has
was.
observed that the liability of the vendee to pay the property tax
Yes.
arises only from the date of sale.
Yes. That is in between transfer and transferee. That is the proportional law. That is correct. But so far as the local authority and the person is concerned, this is 1996 Supreme Court 1579. What it says is transfer of land or building liable to pay property tax even for the pay.
Supreme Court 1579. 1996 Supreme Court 1579.
Yes, ma'am. Yes.
Court officer. Yes.
The first principle is in the says transfer of such land or building liable to pay property tax even for a period prior to such transfer.
Where you are reading?
No, in the head notes itself it is there. First I'll come. That transfer of land or building liable to pay property tax even for a period prior to transfer. That is there.
No, you can't read in some line in between. Read the paragraph, sir.
No. Yes. Now paragraph 15.
Paragraph 15.
Yes. Owner as defined in clause 37 in section 2, he would be owner within the purpose of so liability of transferee arises from the fact of his being the owner of the concerned land or building should not be mixed up or confused with proceedings to transfer. Since the property tax constitutes first charge upon the land or building, and because the land or building is fastened with its liability, liability travels with the land and building. Transferee is liable to pay the property tax due thereupon, not only for the period subsequent to transfer in his favor, but even for transfer. From subsequently, he can recover it from the transfer. That is entirely different. That provision is also there. But who is the owner or building at that relevant time, he is liable to pay. Whether it is a period prior to the transfer or after transfer is not relevant.
What is section 126 there? Delhi Municipal Corporation Act. 126.
126.
Such liability is not curtailed by section 1.
That is in para 12.
Amendment of assessment list.
Oh, yes, the same thing. All similar. All this taxation provision. Commission may at any time amend the assessment list by inserting there also. It corresponds to rule 11 of the tax and fees rules.
And para 13 kindly read. Section 128 is equally relevant.
Yes. Wherever the title of any person primarily liable to pay for the tax on building is transferred, the person whose title is transferred and person to whom the same is to transfer within 3 months of the execution of instrument transfer of registration or after transfer is effected, if no instrument executed, give notice of such transfer right to the commissioner. That is similar to the provision quoted in the order of general signature. There's similar provisions there. In Annex G itself, we have said. Now, the principle is tax is payable by the owner or occupier. Whoever there is the owner or occupier, he has to pay the property tax. Whether it is a transferee, if he is a transferee, he is also liable to pay the property tax prior to the even to the period of transfer. That is the period prior to the transfer. Then he may recover it from the transfer.
What is the submission official liquidator?
Malad, there are two issues involved in this case, Malad. One is, Malad, what is the quantum of tax to be paid either by the company or by the purchaser. That is one issue, my lord. That has also been answered by the learned single judge. My lord, another issue is, my lord, who should pay from which period? That is also been answered by the learned single judge, my lord. My lord, as far as my learned friend quoted judgment in the Supreme Court, my lord, as that judgment will not apply to this case, my lord. For your lordship may kindly take page 17, para 11, my lord. My lord, page, my lord, impugned order, my lord, page 17, para 11, my lord.
Yes.
May I read, my lord? The Honorable Supreme Court in the case of T. Vijayendra Das and other Subramaniam and others, 2007-8 Supreme Court case 751 has held as
We have
under.
already read it, but seen it. Yes, section 55 as far as.
Yes, my lord. Now I come to para 12, my lord. Even though my learned friend has read, my lord, there is a specific mention, my lord. There is no conflict in law in submission made by the learned counsel for the respondent, and the respondent PDO is entitled to require taxes from owner occupier as the land revenue. But the question here is that the respondent PDO has to determine the tax liability to pay in terms of the fact situation and the contract and the evidence placed before him. This exercise has not been undertaken by the respondent. This is the actual difficulty, my lord. He has not undertaken to exercise this issue, my lord. PDO before issuing the impugned endorsement to the petitioner. Therefore, the matter deserves to go back to the said authority for determination afresh of the liability of the present petitioner in accordance with law. There is now, my lord, there is an indication given to the appellant, my lord, to go to determine the tax and give details. And one more thing,
You are ready to pay the amount. If they determine it, you are ready to pay it.
My lord, the para 13, my lord, there is a specific mention, my lord. There is no material on record to show how the arrears of 55 lakh 60,000 as on this is accumulated. My lord, that if they give details, my lord, no material was given by them. If they simply said that you have to pay so much of tax, my lord.
What is this now? What is this order they have passed on 14/17?
My lord?
The order dated 14/9/2017. What is that order they have passed? Have you seen this order dated 14/9/2017? Mr. Somayaji, sir.
Yes.
The copy is not there with me.
What Annexure G?
Annexure G.
No, sir. This 14/9/2017 order you have passed.
Yes, that is we have determined what is this liability up to that period. Up to the after the what is the date of sale. That is.
Yes. Now, so you have to recover the balance amount from. You have made it very clear.
Yes.
That is the reason requested to read it.
That is a
ಕೊಂಡುಕೊಂಡಿರುವುದರಿಂದ ಲಿಟರ್ಜಿಯಲ್ಲಿ ಖರೀದಿದಾರನು ಹರಾಜಿನ ಸ್ಥಿರೀಕರಣ ದಿನಾಂಕದಿಂದ ಮಾತ್ರ ತೆರಿಗೆ ಪಾವತಿಸಲು ಬದ್ಧನಾಗಿರುತ್ತಾರೆ ಎಂದು ತಿಳಿಸಿರುವುದರಿಂದ ಈ ಕಚೇರಿಯನ್ನು ತಮಗೆ 19/7/2017 ನೀಡಿರುವ ನೋಟಿಸ್ ನಲ್ಲಿ ಬೇಡಿಕೆ ಇಟ್ಟಿರುವ 27,68,782 ರೂಪಾಯಿಗೆ ಸಂಬಂಧಿಸಿದ ಮಾತ್ರ ಸದರಿ ನೋಟಿಸ್ ಅನ್ನು ಹಿಂಪಡೆಯಲಾಗಿದೆ. ಯು ವಿಡ್ರಾನ್ ಇಟ್.
Earlier ಏನಾಗಿದೆ, the subsequent the order of the single judge, notice was given. That was effective. That is withdrawn, and then the correct notice.
That is dated 19/7/2017. Whether Annexure G is, what is the date of Annexure G? 1/7/2015. Where is this notice dated 19/7/2017?
May I submit? Annexure H may kindly look into. Annexure H, that first respondent repeats himself as produced. Otherly, the order by dishonor court. Application held filed by the direction to application to pay some of rupees for being property tax payable to settlement council till the date of sale in favor of the applicant who has been confirmed by this court. Notice was issued to official equity and official equity has filed report stating that the amount is available with official equity and in view of that fact that complete liable to pay tax till the confirmation of sale, landowner permission granted.
Well, that is only for permission to pay. Well,
Okay, very well. No. What I submit was whether it's paid by first respondent or second respondent. We are concerned.
Sir, Anexaries, how it is relevant for the purpose of this
Yes.
case?
Yes.
Yeah. Why
Nothing to do
relevant?
with this case.
Yes. What I submit was Annexure G
So
issued is proper.
kindly take us to this notice which you have referred to in this latest order. Kindly read the first paragraph.
ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಉಲ್ಲೇಖದ ನಿರ್ದೇಶನದಂತೆ ಮೇಲ್ಕಂಡ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ತೆರಿಗೆ ಪಾವತಿಯ ಹೊಣೆಯನ್ನು ನಿರ್ಧಾರಣೆ ಮಾಡಿ ಈ ಕಚೇರಿಯಿಂದ 19/7/2017 ನಮಗೆ ತಿಳುವಳಿಕೆ ಪತ್ರವನ್ನು ನೀಡಿ ನಮ್ಮ ತೆರಿಗೆ ಪಾವತಿಯ ಹೊಣೆಯು.
Where is that letter dated 19/7/2017? Endorsement ತಿಳುವಳಿಕೆ ಪತ್ರ ಎಲ್ಲಿದೆ ಅದು? Where is that letter that demand 19/7/2017?
ಅದು ಈಗ ವಿಡಿಯೋ
That we have seen. ಅದರಲ್ಲಿ ನೀಡಿ ತಮ್ಮ ತೆರಿಗೆ ಪಾವತಿಯ ಹೊಣೆಯು
3,27,027
we want to see this 19/7/2017 endorsement.
Yes, that.
Pass out. Pass out.
Malad, may I suggest one thing, Malad, before that, Malad?
No, sir. No suggestion. If you have that copy with you, kindly place it before us. 19/7/2017.
Well, that is for
Yes.
appellant to give it.
Pass out. Yes. What is this? Yes, election matter.
The Advocate General appeared the other day. Was argued on interim application. Advocate General also submitted on interim application. It appears now they have filed 3 other applications before this court on Friday. You also need to file objections to that. Those are also not put up. 2 weeks time will be granted.
The next. That's great. What happened, Mr. Mukannappa? Any compromise?
Let me make one submission. I am appearing for the appellant in all these 3 matters.
Yes.
Am I audible, my lord?
Yes, sir. Yes, sir.
Lord, now the
Yes, sir.
what has been revised and furnished to me by Mr. Mukannappa. Now I send it to the bank. Board meeting is scheduled to be convened on tomorrow. The proposal will be placed as one of the subject before the board meeting tomorrow, my lord. I think some resolution will be passed tomorrow. Development will be informed to your lordships by another 2 days. I could be able to. Because the bank, my lord, the cooperative bank MD cannot solely take a decision. The revised offer was given by my learned friend last occasion. Immediately, I contacted the bank and sent a proposal in writing through my advocate on record. Now, I requested the
Senior counsel. Yes, sir. Senior counsel represent the appellant. Accommodation. Two. Submit the the decision of the bank. As
ಈ ಮೊಬೈಲ್ ಸರಿ ಇಲ್ಲ.
in February 2022,
ಬರೀ ಬ್ಯಾಂಕ್ ದುಡ್ಡು ಹಾಕಿ.
the present issue would be part of the agenda.
No, it is not the
discuss-
part of the agenda. It will be brought before the, it is not the part of the agenda. Agenda have been prepared about 15 days ago.
Where
It will be brought in the
this
meeting
issue-
by the president.
brought to the notice of the this the matter on 21st February as prayed.
Very well. I'm grateful.
Yes. Allah, 18 also same. The matters are pending.
My lord, serial number 19, private.
What to do? These matters are pending before which bench?
Number 19, my lord, the private respondent passed away.
Yes, what is your submission, madam? What is your submission, madam?
Respondent, my lord, private respondent.
Yes, madam, what is your submission?
Lordship, I appear for serial number 20, Lordship.
19, madam. 19.
Sorry, Lordship.
Madam, Irfan Nazir was there. She was making some submission. She was making some submission just now.
Irfana Nazir.
Issue with reference to garden lands, factories, religious institutions. Your team, the court has already directed the advocate general as well as the chief secretary to go in these issues. Come up with
No, that was the matter was decided by the Honorable Apex Court, alva. Then it was Arkavati.
this is not a solution.
My lords, may I?
There is Chandrasekhar Committee's report. Shriram Khan. Yes, madam, what is your submission? Yes, madam, what is your submission?
Private respondent has passed in November, my lord, bring the results on the record, my lord, at least be permitted. Notice not ordered on the previous occasion.
So hear you, madam, we can't follow your submission. There's no clarity in your submission.
My lord, I apologize, my lord. I seem to be having network issues, my lord.
Expired ಅಂತ ಹೇಳ್ತಾರೆ private parts. No more second.
Private respondent has passed away in November, my lords.
We find out, Mr. Consul, private respondent, it seems. In November
My
21,
lords, can you
21, na?
21, my lords, permitted to bring the LRs on record, my lords.
You reported the death of the respondent.
His
number
wife.
two. You have kindly file a memo, madam, with the when he died and who are the LRs
Yes,
of
my
the
lords. I will.
this respondent number.
Yes, my lords. I will file the application. The
Yes,
memo,
kindly
madam.
file a memo, madam. File
Yes,
a memo
my lords.
along
Yes,
with a
my lords.
copy
Yes,
of the death certificate.
yes, my lords.
Kindly report it to the court
My lords.
after serving the copy so that they can
My lords.
file the necessary application.
Yes. I will, my lord, like 1 week time, my lord, please. Yes.
Are you hearing us?
Yes, my lords. Yes, my lords.
Huh?
Yes, my lords.
Credit counsel for the respondent number 2 submits that the respondent number 2 passed away during November 2021 and seeks time to report the same by filing the necessary documents along with the memo after serving the copy on the other side. This the matter. The second week of ಜಾಸ್ತಿ ದಿನ ಆಗುತ್ತೆ ನಾನು let it in the first week. Yes, madam. Are you hearing us? Kindly file the memo, necessary memo along with the documents.
Yes, my lord. I will file it within this week, my lord. This week itself.
I appear for the second respondent, Lordship.
Yes. 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 Sumana Baliga, you are ready?
Yes, Lordship, I
madam?
am appearing. I am appearing, Lordship.
ಬಂದು ಎಷ್ಟು ಸಲ ಹೇಳಿ ಬಂದು ಎಲ್ಲ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀನಿ ಅಂತಾರೆ ಹೋಗ್ತಾರೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಕರೆಯಪ್ಪ ಮೇಡಮ್ ಕರೀತಾರೆ.
Yes, madam.
Lordship, in this matter, court has granted them the alternative remedy, Lordship. Matter can be disposed of.
Madam, you are ready?
Lordship, short accommodation may be given. I'll personally appear before Lordship and
We will see if it is required. Will otherwise no. Yes, sir. Yes. No, the Nanette Council submits that on the ground of alternative remedy, the petitions have been dismissed. Yes. Yes. Now, regarding the one issue that is notification dated 25/6/2010 that has been upheld in view of the decision of the Honorable Apex Court.
fine. These qualifications cannot be accepted and deleted. Whoever having the registration right to enter from the available only. They are invalid. That is the notification. Before the qualifications are concerned. Qualifications are included in the content list.
Now, whether it is covered by this judgment of the.
That is not the judgment. That's the difference is there. Difference, but there is an opportunity given to the state governments. In other cases, opportunity given to the state government on basis of the state government counter and also CCM counter. That was this for judgment.
Ashfaq Ansari.
Yes, Asif Ansari. There were they also filed review. That is online case online 2016.
Have you placed a copy? You have placed a copies, huh? You have furnished the copies to the court, huh?
No, Lordship, we have not
Sir?
received the.
Yes, kindly furnish. Kindly. $19? No, furnish the copies, sir. Kindly pass it on, sir. The copies.
Madam, we are audible, madam.
Petitioner advocate is not audible. Appellant advocate is not audible.
The court is audible.
Yes, Lordship.
No, the relevant paragraphs have been extracted by the Danya Single judge. ಇದು ಬೇರೆ ಕಾಪಿ ಇದ್ರೆ ತಗೊಳ್ಳಿಸ್ಬೇಕು ಸರ್. Where you are reading, sir? Where you are reading which paragraph? No, first let us see what is the issue involved herein. No, regarding this notification dated 25/6/2010. Yes. On what ground you have challenged the notification? What is that notification all about? Yes. Page number? Connection? $578. Yes. $570 is something different, sir. It is something different. That is document 6 R4. R4, R5. R5 is page 584 here. Yes.
So before that, see the amendment which they have made. Before that, I will submit the fact. The Central Act is from 1970 Act in Assam the Act itself. The Town Act was 1970 Act. And there is no limitation for the petition for the petition. Second, there are limitations.
Yes. Act to report officer. This is the Indian Medicine Central Council Act 1970. Item 2 of the schedule.
Item 2. Andhra versus exam body. Between 1922 1975 before that, that is not given to the bottom line. It is decided by our decided by
Yes.
Because in that time is valid. They say, the amendment of draft to that 2010 amendment of draft. The section 14, the limiting blood as a second schedule. Now, the last time is creating the Karnataka Highway, there is same qualification but the other limitation.
Now this is Andhra Pradesh Parishad, Vijayawada. How it is related to Karnataka?
Where?
Page. Take one now.
Andhra, I will present Vijayawada exam wording. Wait this one. Second curriculum, black is there. You know that limitation or validity of the blood.
That is, you are referring to item number 70 to Karnataka Ayurveda Vidyapita Belgama. What? Where you are referring to?
Qualification for registration. That is 19, right? Section 21. 21 says
Court officer ಅವ್ರದ್ದು ಯಾವ ಬುಕ್ ಇದೆ? ಸೇಮ್ ಬುಕ್ ಕೊಡಿ. ಅವ್ರು ಯಾವ ಬುಕ್ ಇದೆ? ಆಯುರ್ವೇದಿಕ್ ಪೇಜ್ So in page 31, it is Andhra Ayurveda Parishad Vijayawada. Then but what about Karnataka? Where is Karnataka here? It is Andhra Ayurveda Parishad.
Andhra 1860 was enacted. Year 1990, Vijayawada was established. Admitted by
It's page 31.
So when I submit the transfer, the second act, year 1970 enacted. So for the Karnataka Act 1961, the section 21, the following district following there, that's not done Tamil. Schedule they don't listen for this one.
Where is Karnataka Act 1961?
Karnataka yoga practitioner district
ಯಾವುದು 1961? Miscellaneous provisions of ತಗೊಳ್ಳಿ, ಅದು ಕರ್ನಾಟಕದ ಅದು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. Karnataka 64 provisions rules 1964. 64. That is miscellaneous provisions act. Karnataka Act number 9 of 1962.
Act 9 of 1962. That the persons who are having the qualifications mentioned in the schedule are eligible to practice.
Yes.
Because by Dr. Page in the schedule, section 21 says the persons who are having the qualifications mentioned in the schedule are eligible to practice. Or qualification for this schedule is also to practice. The petitioners are having this qualification from the Andhra Island President Vijayawada. And because of the distance of the court response recently that they have done as a.
Sir, we will first to get it clarified. We will ask the other side to. So we'll come back to. First, let us. We are not able to follow you, sir. Kindly let us go to the other side. Then we'll come back to facts regarding the facts. Yes, madam. Madam
Lordship.
Sumana Maliga.
Yes, Lordship. Lordship, it so happened. Lordship, here the central government, by amendment to the Indian Medicine Central Act, Indian Medicine Central Council Act 1970, made the amendment, Lordship. Petition, the appellant herein, they had acquired the degree in Vaidya Vidwan. By way of this amendment, their recognition was cancelled, and the Karnataka Ayurveda and Unani Practitioner Board is the authority to register the medicine practitioners, Lordship. They were registered with this board, Lordship. They wanted, because of the amendment, their registration was cancelled. Challenging this, Lordship, they have come up before your Lordship. Now, there is an appeal remedy if they are aggrieved with the problem, Lordship. If they are aggrieved by the decision of the board, appeal remedy lies before the state, Lordship. And with respect to the amendment, the Supreme Court has already upheld the amendment, Lordship. The entire crux of the case is this much only, Lordship.
Yes, Supreme Court judgment for you.
The Supreme Court has already upheld the amendment. Then what will be the scope of the appeal?
That is what I am submitting, Lordship.
Yes, Court Officer.
Ashwik Ansari.
Kindly read the Supreme Court judgment, sir. Kindly read from the first paragraph. No, sir, this Ashif Ansari case, sir.
Ansari.
Delhi High Court judgment.
Madam, which is the Supreme Court judgment in which the validity of the amendment has been upheld?
Rajasthan Pradesh, that is same as continuation of the same paragraph, Lordship. Notification dated so and so upheld in view of the decision in Ashwik Ansari referred supra read with identical issue dealt by the apex court in the case of Rajasthan Pradesh cited supra. Further, there is no violation of section 21 and 35 of the Act 1970.
Rajasthan Pradesh judgment. Read Rajasthan Pradesh judgment. Yes.
the validation date, cutoff date 1961, is the 105 Malad.
Yes, sir.
Second schedule is concerned, I Court of the for the reading of the official provisions, 1978, it will be seen that only degree certificate granted by English officer Sunderland from 1931 to 1961, all have been regularly recognized medical qualification for purpose of section 14 of confirming the right to practice and afford the award of the degree and 1970. With regard to challenge against up to 1967, only on the ground raised under the contained cutoff date is arbitrary. The variant of Article 1 of the Constitution is that no reasons have been disclosed. The support thereof it is stated that both tribunal which was in private rights even after the success of the examination and no change has been introduced in 1967. Important point is that the amount of it filed in the Department of Central Council information apparently created most up to 1967 have been provided in second schedule of the 1970 Act with reference to the information supplied to state government. The information sought by the central government, state government information based on the information that is there in the 1967. The result of prescription 1967 these not be covered. No more. When the draft and special were ordered to confer upon the institution, this is English government were made application in the 14th of 1999 for amendment of the schedule and for all it is after the rights of the including the reason for disclosure is electronic state for situation the cutoff date for regular degrees apply the information to the state government. Also, is not really concerned. So, the first that for 1970 Act, the institutions have given letter or notice. Once the institution given notice, if they are not given any information to state government can never take the government put in cutoff date. Then when based on the state government to cutoff date, where they put it. So for our space is concerned, there is no notice of given to state government of what period this quality is valid or not. Don't go after given to the institution and also to the state government. So therefore, that statement is not applicable to present case. In both cases, three more cases available at the Delhi court. There was specifically state government given opportunity to sell because in concurrent case. So concurrent case is there, right? Both state government and the central government are separate acts for releasing the permission. Based on the information given by the state government, they possible. That is the rules of the state act, central act of the state. But the central act of section 17. Even they have to give notice to the state government. What in the institution, also to the state government, the section 17.
What is your qualification here? Huh? Andhra.
That is accepted even 1995. Both even CCIM also AII that was the location credit of the objective primary also this instance certificate. That's why we say it is affected all times. Also will counter the
So in this notification, the entry from 1953 onwards has been substituted as from 1953 to 2003.
Yes.
So 1953 to 2003. So when they have obtained this qualification in which year?
After 1970, about 1976.
1976, 77.
Yes.
Ah.
But the five subjects also. Now we have to make see the recording of was trying to count with application statement. Page number 411. 411. Is the American Development Tax Karate. Andhra Island Mission is the page 411. The American Development Tax are called the application statement. Two times is application. 411. I think crucial point is the go to the petitioner what the UK government. Then the central government to pass that simply following that. Page 411. 411.
411. What is that?
This is the objection statement of the R4. R4 will kind of the district application.
Yes. Oh.
With regard to one of the repetition, Andhra Island Section, Vijayawada, because Eastern Section Act 21 of the 1860 established in the 1990. The same person recognized for conducting the examination by the exam, which is a 1.5 years course, admitted minority. Then, Para 5, page 411.
Yes.
Para 5. The repetition that the medical education provision is compared key of the schedule 7 of Constitution of India as such both central government and state government are operated legislation is admitted. So what the acts obviously for then even up to 1991 what is the page 413 paragraph number 7.
Yes.
The government of Andhra Pradesh has directed Secretary of Andhra and by proceeding dated 14th and 1991, in presence of the letter of the corresponding letter 6/4/1990, that is the IAM government, not to conduct examination by this one, or not to issue certificate by any validity of certificate already issued. And it's a document. That is the issue by the central government and the state government office only. That is not an issue.
Here they say that the certificates produced by the petitioners at Annexure A4 to 830 are all concocted and fake document certificates. The earlier register viewers register the petitioners in the register against whom inquiry is going on, as directed by the government. Therefore, petitioners cannot rely upon the notification or circle produced by them at either Annexure E or F. These are all fake documents.
They say. They say. We that the advocate on behalf of the court, and they send all the certificates to the institution. But the institution said the certificate issued by a valid one. And the private also appointed.
So they say this Vaidya Vidwan certificate obtained by the petitioner is a fake certificate. Yes.
Now they say that they are not touching that one. The next aspect, they have to prove that transactions are right. Yes. We are not
So it is not on that ground the letter single judge has considered. The letter single judge has considered that this matter is not right.
Based on the structure of the judgment of the Supreme Court and also judgment of Legal Court. That is not 25/6/2010. In that matter, this is not there is state government contracted. Not on basis of the vote of the state government, the central government is special parliament has put the past 2003 and also that 1967 in those cases. But in our case, no opportunity given to the state government or to the institution.
Lordship, court is muted, Lordship. Court is muted.
Yes.
Before any institution is declared, is restricting that they have to notice the section 17.
17. That is rights of persons possessing qualifications.
We submit to the other that and court that will the office as vice the and they also entitled to self practice in any state. Practice. We attend to sign authenticated medical certificates and all that. Now that this is that it has to be accountable by the section. On the court of the study of the examination, the undergoing process required from the candidate at any examination held by any university or medical to the staff, accommodation, training, after consulting the representative of the central government, they send it to the government of the state to which the university, board, or medical institution is instituted. The state government shall forward it on with the remarks as it may choose to make university or board or institution with an intimation of period of which university or medical institution may submit explanation to the state government. On this of explanation, or when no such explanation is submitted, within the period fixed. Then the explain of the period, the state government can make a recommendation to the central government. Then only the second part. Central government after making the private equally, as a benefit, they by notification observe it, direct and entries have been made, non-profit schedule, against said medical qualification, declaring it as survey engagement, medical qualification, only when granted before the specified date. Now, my dear matter, without giving emergency specified date, 1970. Not giving any opportunity predictions or institution or to the state government. Or they can also add to it. And what is it? And medical qualification is when granted to the student specified knowledge and
So this is not withdrawn under section 21. This is by exercise of power under subsection 2 of section 14. Yes, 14, not under 21. Yes, yes. Yes.
Recognition of the qualification granted to certain medical institutions in India.
Yes, yes.
The medical qualification granted to any university, board or other medical institution in India, including second section, my qualification including second schedule.
Yes, kindly read too, sir.
Any university, board or medical institution in India which grants medical qualification not included second schedule, then apply for central government to have such qualification database and the central government after consulting with the then by the and the second schedule to include such qualification. Because even qualification. Now, vehicle qualification declaring that the recognize the vehicle. My case, they are not what I adding. They limiting, reducing. That is for new institutions. 42 is for new institutions. Suppose the new institution started, and after getting report from the state government and also with the concerned department, they can be added in the second schedule.
Yes.
Not to the district level. CCM letter, they 1991, they recognized after 1991 is my institution issued a certificate. I was in 1976, 77, 78. So therefore my medical qualification is very good. Therefore I'm practicing here. Now there is by Indian auditor, they cancel my registration. And we are not able to practice even though having qualification. Second difference between those cases and my case is that yes, state government, that particular section 21, the state governments have given notices and they have made. In fact, my case also that notice was sent to the institution.
Kindly come to page 81 of the your appeal memorandum. Impugn judgment. It is the appeal memorandum thing that is running page 81. That is Rajasthan Pradesh judgments extraction, para 22, section 14(2) of Act 1970. Got it, sir? Running page 81, in page 81. Section 14(2). Yes, yes. Read further. If
that is for inclusion. That's why in that case matter, having to do this is from the amount, it is different under the case.
Then come to 40. In civil appeal number, page 83. 3. Para 40.
Civil appeal number, I will investigate the document Mumbai and the state of Maharashtra this court considered issue the following date the rate and then proposal that covers the thing that comes the name of the imported register on a particular case. The right to practice in any part of the country is not available on the basis of that is only particular state restriction. But when I am practicing in Karnataka state only, right, my decision is given. The right to practice in the district in the sense that only if the name and vice placed in whose central basis and was not practicing anywhere of the country. Suppose if I may heard Eastern Bank in the sector or act, I mean I cannot get that practice anywhere. Eastern Bank in the state also I have to practice only to the state only. The conditions in the section 23 of the Certificate Act are cumulative. So that is not relevant to our case. Not relevant to our case. State government itself after that regulation was given after 1982 and 2003. No, 2 cases. Supreme Court have also delayed. That is not our case today. Not with unfortunate from the respondent, whether any whether this qualification is valid or not, what is your report? Never called for any report from the state of Karnataka. All of this from the state of.
Yes, madam. What is your submission?
Lordship, in this matter, disputed facts are involved. Lordship, kindly turn. Lordship. Lordship, kindly turn to para 4 of the order, Lordship. Learn single judge's order. There it is clearly mentioned that petitioners are the degree holders of the Vaidya Vidwan certificate issued by Andhra Ayurved Parishad Vijayawada. Lordship, in view of the amendment to the section for exercising the powers under section 14(2), Lordship, the central government amended the act, and the validity of the degree granted by the college, Lordship, that is Vaidya Vidwan certificate course issued by the Andhra Ayurved Parishad is limited only up to 1975, Lordship.
How could it be done? How could it be done in the year 2010?
Lordship, that is the central government has
notifying the state, without calling for objection from the state government. How could it be done?
Lordship, I am appearing for the instrumentality of the state, not even to the state, Lordship.
Not to the state, but the council. How could it be done how could it be done retrospectively in the year 2010?
Lordship, central government has to answer that, Lordship. I am appearing for the board, Lordship.
Who is appearing for the central government? Who has issued this notification?
Central government, Lordship.
Who is appearing for the central government? In the connected matter, you can make your submissions. How do you sustain this notification? They have challenged the notification here. They challenge the notification. Where is the central government advocate? What is the prior in your writ petition, sir? You challenge both, no? Let us see the. Yes. How could it be done in the year 2010? The court officer, you call him, but learned counsel. Nobody. You can take notice, sir, if you are appearing for the central government in the other cases. No, we will direct you to accept notice because there is no government, central government advocate representing here. Who represented before the learned single judge? Government of India. CGC for R6, Shivananda. D. Shivananda, CGC for R6. Where is Mr. Shivananda? You are the central government standing council. Kindly accept notice on the, yes. So that is different. Take certificate, they have produced that there is an alternative remedy. The London single judge has directed to approach the appellate authority. Then if there is a challenge to this notification, on this ground that it is retrospectively in the year 2010, it has restricted up to 1975. How the Delhi High Court has upheld that notification? We had to assist the court, sir. Someone has to assist the court. Now, who has filed the wakalat here? No, the Honorable Delhi High Court has observed that in paragraph 15, kindly read it, sir. In this Ashfaq Ansari case, paragraph 15. Huh? Court officer, copy upon wrong Ashfaq Ansari case. Supported by kindly read from 15, para 15. You can read para 14 also.
Already existing equally untenable. The section 41 of May introduced qualifications granted by any university or other the central government, after consulting central council, may after the second schedule, so as to include such qualification therein, and any such only when grant after specified date. That is after specified date.
Next.
The exercise of the power in section 42, that the government issued the by virtue of item 6 relating state patent of the item 7 from 1953 onwards. Court has been subsequently it is not up to the Second Amendment. Qualification is created state legally established they are not changed. Recognized by the act after 2003. That is state government is not a past act. Therefore, only up to 2003. Thereafter, it is not valid. Where it means that the Second Amendment under the no substance integrated the deletion of the qualification because of the petition. In that case, state government itself has not valid.
Not a state government, sir. It is a 25/6/2010 notification. It's a very same notification, but there it is item number 6. Here it is item number 2. That's all the difference. Yes. No, sir. That is the same thing. Here item number 2. There it is item number 6. That's all. No opportunity has been given. How can you say that no opportunity was given? Granted by the.
We found the find that
No, their question there, the argument was there, GAMS was already there in that notification. Now that recognition has been removed. That is, the further contention is the amendment affected by the notification that is 25/6/2010 cannot be applied retrospectively from the year 2003. So it was, here it is 2005, there it is 2003. It was from 1953 onwards was the earlier notification that was substituted as 1953 to 2003. Here it is 1975 to 1975. That's all the difference. Yes. Yes, sir. Yes, we understood. Yes. Yeah. Yes. What they have admitted in the counter. Now we requested you to read this paragraph 15 further, sir. Now we have read para 8, sir. Kindly read para 15. The amendment has only clarified the position. Read para 10 also. Sorry, yes, that is.
is the Ayurveda. Well, that's the next unit. After they are taking off the blood. This is the takeover by the university. Therefore, after that,
Kindly, we requested you to read kindly para 15. Para 15.
Not being taken after 2003. Right. After 2003, we are going to use that amendment and but then the kindness is defense rate. When the active amendment is state government is added amendment. That is right. Yes, status of Ayurvedic Iranian medicine
Sir, there it was from 1953 onwards. That has been substituted from 1953 to 2003. Here there was no prescription given. Yes, for this. Then this was given as serial number 2. Now it is made as entry from 1923 to 1975. That has been inserted. Yes. Yes.
Yes,
578. 584. Yes, we are at it. 584. Yes. 584. Yes, sir. ಮುಂದೆ ಹೋದ್ರೆ ಓದೋದು ಇಲ್ಲ ಆಮೇಲೆ
Second schedule is to be so far as the petition considered item 2. That's the matter. This can all these columns correct. They gave after the state government. Not of the state government. After the state government, all other states. About the
yes, we will consider your points, sir. Yes.
Supreme Court judgment, my last judgment. This is Supreme Court judgment on it, and the Delhi Court is confirmed.
Yes.
Without any Supreme Court judgment.
Court officer ಅವ್ರಿಗೆ ಹೇಳ್ತಾರೆ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಅವ್ರಿಗೆ ಯಾರು ವಕಾಲತ್ತು ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಯಾರು ವಕಾಲತ್ತು ಫೋನ್ ಮಾಡಿದ್ವಿ ಅವ್ರು ತಗೊಳ್ತಾ ಇಲ್ಲ ಮೆಸೇಜ್ ಎಸ್ Now we are requesting you to read kindly for paragraph 15 in full, sir. We are stopping at one point. You are not reading further. Yes, kindly read it full, sir, for our satisfaction. We are requesting you. We are of the view that yes.
You know that the amendment had no amendment only clarifies ANS qualification, non-ANS qualification after 2003 and held in Supreme Court. We have to get controversy to that. That's what I agree. The often finds the Supreme Court judgment.
No, kindly read it further, sir. We are requesting you. Yes. Learned counsel for the central government, kindly assist the court, sir. Kindly assist the court. We will have it. We will release the matter tomorrow. Kindly assist the court. Furnish the copies to the other side, sir. No, who is the learned counsel appearing, sir? With great respect. We heard the learned counsel for the appellant. To secure the presence of the learned counsel for the central government, list the matter, release the matter on 16th February. No, sir. It doesn't matter, sir, if you are coming from which place. It doesn't take any. Yes. No, then we will release the matter tomorrow. Release the matter on 15th. Yes, you convey to the other counsel for further arguments. Madam, you also study on this aspect.
Please, Lordship. Please,
Whether
Lordship.
the counsel is submitting that in the other matter state government consultation was made, whether it is required to consult with the state government and whether council has consulted.
Please, Lordship, I'll get the instruction in those regard and I'll make my submission.
Better you come physically also.
Please,
if it is
please,
not
Lordship, I'll come.
happening.
That's the reason in the beginning itself, I requested your Lordship to have a short accommodation, Lordship. I'll come personally, Lordship, and assist the Mac court.
Yes. No, this is not a way. With great respect to you, sir. This is the division meant, and you have not furnished any of the judgments which you are referring to, and we are getting it from the court now from the court. Sir, you are supposed to place it before the court in advance. If you are referring to some documents, the copies of which you are referring to, the public time is waste of public time like this. Yes. Serial number? Yes. This is for production of additional documents. Admission. Yes.
1989.
KPTCL has filed,
Yes, KPTCL has filed. What has happened in the judgment? It shows as KPTCL.
Yes.
What I explained, the reason that has happened is also because the earlier round of litigation, KPTCL and KPTCL both.
Yes.
So when the school was established by the then ABB. ABB established the school. And then it was handed over to KPTCL.
Yes.
It was handed over to KPTCL. ABB school was established, it was handed over to KPTCL.
Yes.
That school management were all the employees of KPTCL at that point in time who were studying there and also nearby villages. So what happened is in 1989, the replacement is appointed. After that, there are orders are regularly issued upon him on a temporary basis. Now what happens is in 2002, KPTCL and KPTCL did not start paying 50% of that school.
Yes.
Because the expenses of the school are being paid 50%. So this is a granting agency. So there are 3 employees for whom the granting agency is extended.
Yes.
Now what happens is the retention is signed in 2002. In the retention which is signed in 2002, KPTCL is the 9th respondent, KPTCL is the 4th. The direction is for the school management to regularize the petition. The regulation is allowed now with retrospective effect to regularize. The writ appeal is in the writ appeal because the order is modified. So retrospective cannot happen, it has to be only prospective. Thereafter, in 2012, the school regularized. He finds the retention. He finds the retention during the pregnancy retention on the education department. There are 2 types to do the retention. In the first one, one is for the management regulation. Second is to give a grant aid, to consider giving grant. Now what happens is that the grant aid, the state government says cannot be given for a grade D through the employee, grant aid cannot be. Now he finds another retention. In the other retention, what he says, he drops KPTCL as a respondent. He only makes KPTCL as a party. And he says that KPTCL should regularize. And the regularization that the school is incorrect, it is not in compliance with the single judge judgment has given a direction to KPTCL, but KPTCL was not a party. It's actually to KPTCL. Although the order says KPTCL was never a party. It's actually a direction to KPTCL. KPTCL was only person represented. There is a direction which is given to KPTCL for regularizing as an employee of the power corporation. And thereafter for the government to give a granting, positive action. Because the granting can only be given to an education institution. The school is a separate society registered under the society. The school gets granting. So, effectively, the order of the level single judge, right? If he is employed of the power corporation, then granting obviously cannot be given. So, therefore, the second part of the order is. But if he is employed of the power corporation, he can try in the case of mobile.
Yes, notice.
There is a positive direction issued to KPTCL to regularize the state.
You regular is subject to the result of the writ appeal. Consider regularizing the service of the petitioner. Directed to consider. No station. It is only to consider regularizing the service.
I appear. Is it 29?
23, my lord.
I'm sorry.
I appear for appellant, my lordship.
My lord, yes, madam. I for the respondent. I received the entire set of the copies from my learned friend, my lord. As directed by lordships, my lord. The next meritorious candidate is the appellant. Lordship may kindly page number 64, my lord. 68, my lord. Is the selected candidate list of the candidates wherein my lord Srimati Hemalata Kum Cheluvaraju so and so she secured 290 marks in the SSLC, my lord. She secured 46.4%. As against this appellant Srimati Rupa, she secured 257 marks in SSLC and her total percent is 41.12, my lord.
Yes. Yes.
The Hemalata, who is the respondent in this case, my lord, she secured higher marks. Because of that reason, the selection committee is selected the fifth respondent in this appeal, my lord.
It has been set aside by the land single judge.
Yes, it is true. It is true. It is which has been set aside and remanded back to do some fresh exercise for the selection of the to the post of Anganwadi worker.
Since I am the eligible candidate as on that day, my lordship, my candidature has to be accepted by the committee and I should be appointed, my lordship. She has filed the fifth respondent filed the incomplete application, my lordship, before the selection committee.
Now the director to conduct selection afresh anta ide.
Yes, my lord. Yes, my lord.
That cannot be done, my lordship, because my age is barred, already barred, my lordship. Since, my lordship, as on the date of recruitment, I was eligible and I submitted all the records, my lordship. My candidature has to be considered and I should be appointed, my lordship, in place of fifth respondent. Instead of conducting.
Why the appointment of the fifth respondent was quashed?
My lordship, she has not at all produced all the relevant records, which is mandatory as per the notification, my lordship, by annexure A.
Instead of producing a residential certificate, my lord, she produced the caste certificate, wherein it is very clearly mentioned her address also. Lordship may kindly.
So what is your instructions? Now shall we direct the authorities to consider the candidature of this appellant instead of going for a selection afresh?
Not single judges directed the authorities to
At least we will set aside that order. We will set aside that order because now going for the selection afresh would disqualify the other candidates who have already participated in the.
Yes, it is true, my lord. She was born on 17/7/1986. Now she is age barred. It is
because
true.
there was
You can
no
see that.
default on her side, no mistake from her side.
Yes,
it was because of the fifth respondent has failed to produce the relevant documents. For that, why the others should suffer?
It is true, my
If
lord.
the
It is true.
yes, if the fifth respondent was not qualified and she has made some efforts, then they denying the rights of the other candidates who were entitled to at that time. Why should we deny that right which was existing for the appellant during that relevant period?
I leave it to court, my lord. I leave it to court, my lord.
Yes.
As on the date of interview, she was qualified.
She was qualified.
Yes, my lord.
It is because of the default committed by the fifth respondent. Now the appellant is made to suffer.
It is true.
Fifth respondent has not challenged the order of the learned.
No, it is not. She is not challenged. She is not at all participated, even served and unrepresented.
Even in the present proceedings.
In this appeal, my lord.
She is not challenged it, and even she has remained absent here also.
Yes, ma'am.
Nishan Munni. Appeal is allowed in part. The order of the learned single judge Question. The issued order of appointment of fifth respondent, bearing number so dated 16/2016, that is if issued by the third respondent, remains undisturbed. Next, respondent numbers 2 and 3 are directed to consider the candidature of the other candidates who had participated
Appellant only.
for the
Candidature of the appellant. Candidature of the appellant, my lords.
There are other one also.
My
No?
lordship,
That
she-
is,
she-
who is eligible, let them consider it.
No, my lordship, she has also not produced the necessary documents as on that day.
Let them examine it.
Yes.
That is not forthcoming, my lord, but she scored only 229 marks in SSLC.
Meritorious. I'm
That is
meritorious, my lordship.
36.64% in the SSLC. But regarding the
Selection of,
documents, there is no
respondent is
records
not
on the file.
questioned by her.
Candidature of the other candidates who had who had applied for the post of the Anganwadi workers at Anganwadi centers of Srirangapatna Taluk.
Srinivasa Hagrara.
Srinivasa Hagrara. Srirangapatna.
Correct.
If otherwise eligible, let them consider the candidates if otherwise eligible and take appropriate decision in accordance with law in an expedite manner in any event not later than 2 months from the date of the receipt of the copy of this order.
Please, my lord. Oblige.
With aforesaid observations and directions, the order of the learned single judge is modified, allowing the writ appeal in part. Yes. Yes. Lease cum sale agreement, registered lease cum sale agreement. No, this 661 at Arkavati layout, it is not in possession of the BDA. No? You are ready to allot any other set, alternative site. Huh? This notice, yes, production of the translated copies of the annexes is dispensed with at present. IA 2 of 2021 stands dismissed as not pressed. Issue notice on the main appeal as well as an IA 1 of 2021. No, we can close the matter. We can ask whether he's ready for any alternative site. No, in his absence, we cannot grant any stay order. Yes. In addition to the normal mode of service, learned counsel for the appellant is permitted to take a service of notice on the respondent through the learned counsel who is representing the respondent in the pending contempt petition number CCC 600/2021. Yes, this is the matter. Issue emergent notice. Issue emergent notice. Yes. In addition to that, you can take out this. Next Monday, it may not be possible. It's the matter on 28th February.
The first one is their certificate in the authority. This is not. Or get a certificate to other freedom fighters to say that he is jailed for 1 year. What if it is they give one certificate for 1 year? You must send a freedom fighter who was in jail only for 6 months. So he could never say as to whether he was in jail for 1 year or 1 year. How about that means instead ask order? Saying that you have to give the benefit because he is actually just doing it. You not prove as to whether this is more than 1 year or not. So not is concerned. If I don't follow the rules that are being myself, but I ask them how am I going to ensure that people who are not even being paid for what is eligible, we don't know the some certificate. Now we see the applicant is fine. Why not be valid fighter or not? Page number 48. This is the applicant, only one applicant is right. The requirement of the law is asking 2 applicants.
No, what was the claim made?
He will not offer pension on the basis that he is a freedom fighter. Now, to be eligible for that pension, he must have been in jail for a period of 1 year.
Pension from which year?
Pension not available in the order. As when the order is passed, then from that day pension is paid. The order was eligible to give the application in 1998. In 1998, he made an application. Then he is taking pension as a freedom fighter because I have put in service as a freedom fighter for the country. And I was in jail for a period of 1 month.
During which year?
1940.
But the application was made in the year 1998.
1998. But it is not that we want to reject any application. Like a freedom fighter, we have to be. So we said you have to show documents to say that you will jail for 1 year.
Yes.
Then not because only the jail is very supposed to go records are available. But along with this application, we filed an affidavit. One of the requirements is because old record is not there. So we are also happy to take application to 2 affidavits of 2 people to be in jail and to get the inspection.
Yes.
So we asked for an affidavit. We only 1 affidavit.
Yes.
But if I say there is 1 affidavit, it means that 1 affidavit should say that the person was in jail for 1 year. So please see that affidavit.
Now we will direct him to file a better affidavit. Yes. Yes.
Someone else, third party, freedom fighter, otherwise it will move forward. I would want to find a freedom fighter as I was arrested and convicted to 6 months, 6 months, rigorous imprisonment on 294. The first class sanction away. I was then transferred to Central Prison, India, there was 392. This has been confirmed by Superintendent Central Prison Bangalore, but certificate number dated to while I was in Central Prison, I happened to meet the Muna Venkupara design because in the jail of Ola who was reported and brought to Central Prison 1992. Now, I am in jail 6 months. I cannot on oath confirm someone has been in jail for more than 1 year. Because he himself was in jail for 6 months. So, based on this certificate, I cannot say. Because
No. What is the other affidavit you insisted?
Otherwise, record of the jail, all the certificates from a member of parliament so these three are the requirements, and not that is the rules separate. He rejected it, the draft is not able to do it. Also, the other thing that takes very sympathetic view. I don't see anything wrong with it. But I don't want to pay someone who is not entitled to it. So far the state is concerned, state cannot be directed to pay someone who is not entitled to that money. This is the water one. The water, in my humble submission, does not take into consideration the fact that this affidavit of one freedom fighter is not in the manner that is required. Page 16.
So the affidavits of 2 co-detainees was required.
Even that one affidavit should say that he was in jail for 1 year. It is one. Saying he's very old, he can't get it, all of that. Even that one co-detaining should be for either 1 year, he was in jail for 1 year. So the affidavit does not even say that. But I am not completely sympathetic for all the freedom fighter. I can't allow the state give payment to someone who does not require satisfy the minimum requirements of what the rule provides.
But he says that he was brought in there on 9/10/1942.
All the states is important. All the affidavit says is that he was brought because this state was there only for 6 months. Mr. Kapoor was only there for 6 months. He can never certify that someone was there for 1 year. And he does not. He is very careful. Affidavit is also very careful. He does not say. He said, I saw him over 1942. And all, whether he was there 1 month, 2 days, 3 days, 1 year, nobody knows.
Yes, sir. Yes.
Documents to show that I was not late for money, get it to do. Otherwise, you will also keep not keep back. Fact meant that I was there. Their condition is that I whether I was there for 1 year or 1 year. Get the document to show that I was not there. If it is there or not, then the interest is belonging in matter. And what is the time length in which you are asking you? Well, also to write is even if the person is born in 1947, it is 75 years. Even 15 years, we put it back. They are all no one will survive it, and there is not in the next year. Only few people survive, and they are not.
Now you are claiming arrears, huh?
Not arrears. Total is 98.
Now you are claiming the pension from 98. 98. Now how much it works out to from 1998?
That will satisfy the problem.
Now is there any other document apart from
no one has ever said except for present time.
No, Learned Additional Advocate General submitted that MP or MLA can also give some certificate.
Well, if we are one of the present documents, all destroyed. If that is very easy for them to destroy, whereas I can you will also look at it. Give me such a situation. And why is you are a secretary? From actual what is involved? How can I talk?
No, any other document, the certificate of MP or the MLA.
Guideline is over. Guideline is over. It is practically impossible. And you will also to understand it is a guideline is somewhere 5 years, 10 years to be something. We are 75 years. And 75 plus another 5, 10 years you add at least 80%. And it involves again. If the appearance of the government is that a lot of people one of the grounds I have taken then you are not should take the inquiry made by Gandhi, what he says. Please see. May I read it?
Yes.
The local inquiry is but this is correct for the 6 months. So this is 9, 10, 19, 1 hour. The movement many years participated from that day. When you are 50%, participating to how long you are there, it is not there. 9, 10, 19, 1 hour. Delivery and tomorrow we see. During that time, I took part in 50 months to read it, 80 parties. There are those arrested as so under detention is empty. I took part from 1942 till 1943.
But he is a freedom fighter. That is reflected from the Tehsildar's report. There is no dispute that a stranger has come and he is seeking for this pension amount.
I must and there are not turn around and say, so then many others will be like so maybe they will take 1 month. Once you got to certain description and organization, you can just 1 month. You can't just be done 1 person. What you not very great data, even the period of maintaining, for instance, like the relation that is not why this 1 year in jail must be something. You don't jail because forest sector or after 2 4 days. So they are at the same time. Now, you finally only 98. 98 cannot only be 1 affidavit. We try everything. We also whatever we just get to even as I said, find out what is happening. Finding is only the truth. That is the case if you not intend to why not the government will have to pay? It's not intended. And after how many years? 1942 is 47 is got a difference. 1998 the application. Continuously there is something going to happen. They know because our notification fixing these requirements is 95.
Well, now if we admit this matter, we don't know what could be the fate of the case.
You have the.
He's already aged about more than 94 years.
Now we live implementation question comes from the order. What is the application? First in the judgment started to be the application like it goes started up to all the and limited to the date to whatever. But I will sound extremely harsh when I argue these things, but then the result is the president of the state. I have to follow the rule.
Now you are ready to pay from the date of the order. Huh? Now what would be the arrears if it is from 98?
You have the original application.
And this rupees 1,000 for the delay of each day group that may yes.
I followed the rule and said, you're right, because English say you have to 41 seems
As per the scheme, an application is supposed to be filed in a format.
There is no photograph also. No photograph, no photo. ಏನದು ಕೊಡು? What are these documents? That is from 18/5/2010. From the date of the issuance of this order. Which Adesha? Earlier, what was the ruling? This is not the pension, Ankar, Gauravadhana. Welfare honorarium, sanction of honorarium. 2010. No, in this notification circular of the corrigendum, what has it showed there in the first page, page 10, kindly read it. 36/1992 was the last date fixed. Kindly read paragraph 2, sir. Yes.
That itself indicates that it was made between 1919 and 1995. So that there was a requirement for 1 year, but it is not satisfied.
We'll continue at 2:30. That's good. Next week. Next week. What's the matter on 22nd February? That's great. By the learned counsel appearing for the respondent. Yes.
Serial number 38, please, my lord.
No mentioning at this hour, sir.
Please, ma'am. Court officer. Court officer.
ಸರ್ ಬರ್ತಾರೆ.
ಸರ್ ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 38 ಅಡ್ಜರ್ನ್ ಆಗಿದೆಯಾ ಮೇಡಮ್?
ಎಸ್ ಸರ್.
38
ಎಸ್ ಸರ್.
ಅಲ್ಲ, ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು.
29 ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಡ್ಜರ್ನ್ ಆಗಿದೆಯಾ, ಪೆಂಡಿಂಗ್ ಇದೆಯಾ ಮೇಡಮ್?
ಸರ್ ಇದೆ ಸರ್, ಮ್ಯಾಟರ್ ಇದೆ ಅದು.
ಓಕೆ. ಹಲೋ, ಹಾ ಹೇಳಿ. ಹಾ ಹೌದು, ಹಾ ಹೇಳ್ರಿ. ನಾನು ಆಫೀಸ್ ನಲ್ಲಿ ಇದ್ದೀನಿ. ಇಲ್ಲ ಇಲ್ಲ, ಆಫೀಸು ರೀಚ್ ಆಯ್ತು. ಅದ ಅವರು ಹೈಕೋರ್ಟ್ನವರು ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿರ್ಲಿಲ್ಲ. ನಾನು ಹೇಳ್ದೆ ಒಂದು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಇಂದ ಇದು ಬೇಕಾ ಬ್ಯಾಡ್ಗೋ ಒಂದು ಪುಸ್ತಕಗಳಿಗೆ ಇಲ್ಲದೆ ಹೋದ್ರೆ ಸುಮ್ಮನೆ ವೇಸ್ಟ್ ಆಗುತ್ತೆ. ಅಷ್ಟೇ ಸ್ಟೂಡೆಂಟ್ ಸರ್ವೆ ಆಟ ಆಡ್ತಾ ಇರ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಇದೆಲ್ಲ ಸರಿ ಅವ್ರ ಟೈಮ್ ತೊಗೊಂಡ್ರು ಒಬ್ಜೆಕ್ಷನ್ ಆಗ್ತೀವಿ ಅಂತ ಹಾಗೆ ಹೀಗೆ ಅಂತಂದ್ರೆ ಇಲ್ಲ ಒಂದು ಅಲ್ಲಿಂದ ಒಂದು ಇಲ್ಲ ಅವರೇ ಹಾಕ್ಬೇಕು ಇವಾಗ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜೆಯ ನೋಡೋಣ ಏನಾಗ್ತದೆ. ಡೇಟ್ ಕೊಟ್ರು ಯಾವತ್ತಿಗೆ 18 ಕೊಟ್ಟಿದ್ರು 22 ಕೊಟ್ರು 22 ಕೊಟ್ರು. ಊಟ ಕೊಟ್ನಲ್ಲ ಇನ್ನೊಂದು ಸರ್ ಎಲ್ಲಿ ಕೊಡ್ಲೇ ಇಲ್ಲ ಅವರು ಇಲ್ಲ ಕೊಡಿ.
ಅದೇ ಫೈನ್ ಹಾಕಿದ್ರಿ ಸರ್. ಅದೇ ಮನೆಗೆ ಕಳಿಸ್ಕೊಟ್ಟಿದ್ವಿ. ಅದು ಇನ್ನೊಂದು 4137 ಒಂದು ಆಗಿದ್ದಾರೆ ಸರ್. ಅದೇ ಅನೌನ್ಸ್ಮೆಂಟ್ ಹಾಕೊಂಡಿದಾರಲ್ಲ.
ರೆಡಿ ಮಾಡಿಲ್ಲ ಸ್ಟೆಪ್ ನೋಡಿದ್ದಾರೆ ನಾನು ಹೇಳ್ತಾರೆ ಕೇಳಲ್ಲ ರೆಡಿ
ಫೈಲ್ ತಗೊಳ್ಳಿ. Court officer. Court officer. ಕೋರ್ಟ್ ಆಫೀಸ್.
ಮಹೇಶ್.
ಹಾ ನಮಸ್ಕಾರ.
ಹಾ
ಬೆಳಗ್ಗೆ ಟೈಮ್ ತಗೊಂಡೆ ನಿಮ್ಗೆ ಇದ್ರಲ್ಲ ನೀವು.
ಇಲ್ಲ ಅಂದ್ರು ಮೇಡಮ್.
20 ಕೊಟ್ಟಲ್ಲಿ ತಗೊಂಡಲ್ಲ.
20ರಲ್ಲಿ ಇಲ್ಲಿ
ಇಲ್ಲಿಲ್ಲ, ಈಗ ನಾ ಹೇಳ್ತೇನೆ ಈಗ.
ಓಕೆ ಓಕೆ.
ಅದಕ್ಕೆ ಅಲ್ಲ ಕೋರ್ಟ್ ಆಫೀಸ ಇಲ್ವಾ ಅನ್ಸುತ್ತ ಅವ್ರ ಪಾಪ ಅಲ್ಲಿ.
ಇದಾರೆ, ಈಗೇನ್ ಬರ್ಬೇಕಲ್ಲ, ಬರ್ತಾರೆ.
ಅಲ್ಲ ಲೇಟಾಗಿ ಹೋದ್ರು. ಆಯ್ತು ನೋಡ.
ಓಕೆ.
ಕೋರ್ಟ್ ಆಫೀಸ ನಾನು Your lordships kindly.
Kindly wait, sir.
Your lordships kindly.
Kindly wait, sir.
I'm sorry.
Serial number 29.
I appear for it. 29.
I appeal for the
I
respondent.
request your lordships to kindly take up the file 2247 of 17, my lords.
No, learned counsel, Mr. Shivakumar is seeking time.
Alla, adralli, I want to point out something else. Adike, WA 2247 of 17, nodidre your lordship will pass some other order.
Yes, codified.
Adu number 2, appellant number 2.
Sir. Monitor ಸರಿಯಾಗಿ ಮಾಡಿ.
Appellant number 2, my lord.
Yes.
Please, my lords. So normally, your lordship. Your lordship got the file, my lord. WA 2247.
Disabled,
Ha.
Whether I am disabled?
How do so?
Yes. Then list the matter before any other bench where honorable assist is not a member. Yes.
Oblige, madam.
Yes. Now the dispute is 1 acre 27.5 gunters. No, for the other portion, you know very well whether the title passes based on the agreement. Agreement of sale is not a document for transfer of title. Yes. Yes. So there is no sale deed in your favor. Yes, yes. You are claiming your rights only on the based on the agreement of sale. Yes. No, now that is not a dispute here. No, that is not a dispute here. Now the dispute is only 1 acre, 3 acres, 14.5. Then why this in the page 16? They kindly come to the learner single with this order, page 16, paragraph. So you are claiming your rights 1 acre 27.5 guntas is as per the sale deed. 1 acre 27 guntas. So the remaining is 3 acres 14.5 guntas. That will not confer any title, sir. That is why to implement it only, that matter has been referred to this to implement it. To implement means 1 acre 27.5 guntas to 27 1/4. Your name has to be shown as per the sale deed. Yes, but then for the 3 acres 14.5 guntas, yes, both respondents' name is to be shown. Which is not a remand to implement, to give effect to that order. Tahsildar has to give effect to that order, that's all. No. It is not remand. It is only to give effect to that order. Anyway, that will be subject to the outcome of the civil suit. ಮಾಡಿದಾರಾ ಹೇಳಿದಾರಲ್ಲ subject to the result. I am of the view that the mutation entry certified and effected in favor of the petitioner's uncle would be subject to the result of the pending procedure. Who is petitioner's uncle? No, who is petitioner's uncle? Effected in favor of petitioner's uncle. What is the subsequent development? To effect changes in terms of the sale deed in favor of the ancestors of the petitioner. ಅವರು ಹಾಗೆ ಹೇಳಿದ್ದಾರೆ ancestors of the petitioner ಅಂತ. Pursuant to the order passed by the first respondent, Deputy Commissioner as per Annexure E has given effect to the order under challenge and accordingly mutation is affected. So as per Annexure E, the mutation is affected in whose favor? Page 21. No, that is already given effect to the order under challenge. Where is that order where it is given effect to? This year. Where is that? In whose name that has been effected? Invitation entry certified and affected in favor of the petitioner's uncle. Yes.
Remember 291. There is no mistake for that. Petitioner cannot purchase the land to the extent of 1 acre 27 guntahs on Millards 27 acres. On that Millards, all the authorities, including the red villages, that is known to invitation can be done. He is not agreed by that.
Yes.
1 acre 27 because of this of the transfer of property by a signatures. This claim belongs in respect of 3 acre 49.5 because of the same survey based on the agreement process.
Yes.
Alleged to have entered during the time period of the 1967. There is no pleading to that. So all the revenue authorities, the commissioner as well as single judges, there is no title passed to you as far as 3 acre 49.5.
Yes.
And court will respond who is the Lord's who is the Lord's successor of the original grantee. He is favor regranting. So he has got the title. Regranting is done in favor of the court will respond. On that basis, Lord's deputy commissioner is directed to re-enter the name of the court will respond so far as 3 acre 49. Single judge has said that in addition to that, Lord's court will respond. I cannot know whether he has 1.5 suit for title declaration. That is dismissed. Here, dismissal will not confer any right to my land. Here, his suit is dismissed. That does not mean that his agreement will become a sale deed. That will not happen unless transfer of property.
That suit is filed by whom?
Filed by the court responding.
What is the relief claim?
The suit for declaration. Email question, I do not know on that. And against that dismissal, he has filed.
So you have entered into the sale agreement. No, he has entered into sale agreement with whom?
With the father of the court.
Father of the court.
Father of the court is one for 3 acre 14. The agreement is still agreement. Agreement of so many sectors. On that agreement, there was no relation can be unless he gets.
What is the date? What is the date of that agreement? 19? 27/3 ಅಂತ ಇದೆ. 17/3 1967.
Or I am going to civil performance about agreement
No, we will not go into all that. Whether there is limitation for you to seek for a suit for specific performance, 67 agreement.
Legal argument, nothing to do with the parties as such. Even I also dismiss it. He will not get the right. Even I the court respond, appeal also dismiss it. It is his declaration. His declaration does rejection does not confer any right on. It is merely an agreement for the whatever it is available.
That RA is filed by whom? Court response. Against whom? Against you. No. No, that thing. Yes.
Except that uncle one point, I don't know how it has come. Uncle or last subject to RA. Any other civil.
It is already there. Subject to the outcome of RA.
Proceedings between the parties. So if regrant is there, that is the reason court is called name is there. The commission is not committed in here for the reason that regrant is done in this. Unless he has to challenge that regrant or
No, regrant is on 17/3/2001.
and under him only is clear. If
regrant goes, again, we will not.
So the regrant is in favor of fourth respondent. Father of the fourth respondent. Father of the fourth. But your agreement is of the year 1967. Whether it is registered registered agreement.
Immediately you would have imposed an agreement, or they would have filed a suit for adverse position, whatever. But they can't wait for somebody's declaration to be dismissed on that. I get the right to implement also agreement. Yes, but independent suit, the declaration.
No, it is whatever it may be, by virtue of this agreement of sale, no revenue interest could be mitigated. It is well settled now, sir. Yes, sir. Yes. We will not go to the other aspects. For what reason the sale deed has not been executed? What was the understanding between the parties? Why should we delve upon all those issues now? Here, when we are considering the revenue entries as such. Anyway, it is already decided by the learned single judge that it will be subject to the outcome of our. It is there already. No, where is this said? One number. Mutation entry certified and effected in favor of the petitioner's uncle would be subject to the result of the pending proceedings in RA number 7. We don't know who is the uncle of the petitioner. No, there is no dispute regarding 1 acre 27.5 meters. Yes. No, that petitioner uncle may be respondent number 4 of the petitioner uncle and Tagigan. Other there dispute ilvala. There is no dispute regarding that 1 acre 27.5 meters. Absolutely, there is no dispute. The dispute is only with respect to 3 acres 14.5 meters. Yes. Yes. This is for IFR recalling the order. That would be better. We'll recall the order. Yes. The order that for the reasons set up in the affidavit accompanying the application. The order dated 13/12/2021 is recalled. The matter is restored to her. And we heard the limit on counsel appearing for the parties and merits to find no reason to interfere with a well-reasoned order of the one single judge. However, we clarified that the revenue entries mutated and affected in the name of the respondent number 4 by the Deputy Commissioner, that's respondent number 1, to the extent of 3 acres 14.5 meters of survey number 291 of Pagepadi village shall be subject to the result of the pending proceedings in RA number 49 of 2016. In the result, detective stands dismissed. Serial number 14. We'll not pass over the matter at this hour, sir. Yes, pass it on. Nineteen 2017 on. Sir, as per this letter dated 19/7/2017, we have computed the total liability. The demand made is only to the extent of this 14/27/26.
No, this is not like that. 2011-12 to 2015-16.
Allah, 2011-12 ಗಿಂತ 2017-18
out of that annexure G. And that is for subsequent year. Annexure G pertains to up to 2015-16. That is why from 2011-12 to 2015-16, 5,64,945. That is what he has paid. Now still 47 lakhs has to be paid. Now the direction was complete from
Now you have made the demand from 2011-12 to 2017-18.
Allah, 15-16. That is first line. In 2017.
Allah. That is in annexure G, sir. Now kindly come to this 19/7/2017 letter.
ಅದರಲ್ಲಿ first 2011-12 to 2015-16, 5,64,945. That is annexure G. The annexure G pertains up to 2015-16. So 5,64,945 out of 53 lakhs is paid. Now still 47 lakhs has to be paid. From date of sale till 2015-16, that is 5,64,945.
Start they have paid. Kindly read the text. Kindly read the text, sir. ಅದನ್ನು ಓದಿ ತಾವು ಆರ್ಡರ್ ಅದನ್ನ ಲೆಟರ್ ಮೇಲ್ಕಂಡ ವಿಷಯ
ತಮ್ಮ ಸಂಸ್ಥೆ ಖರೀದಿಸುವ 10 ಸ್ವಕ್ಕನ್ನು ಬದಲಾವಣೆಗಾಗಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಪ್ರಕರಣ ಹಾಗೂ ಆದೇಶ ಸಂಖ್ಯೆ ರೀತ್ಯ 11-12 ಸಾಲಿ ಒಟ್ಟು ತೆರಿಗೆ ನಿಮ್ಮನ್ನು ಪಡೆದ ನೀಡುತ್ತಾರೆ. ಅದು ಈ ಕೆಳಂತೆ ವಿವರಿಸುವುದು 2011-12
ಯಾವ ತರ ಡಿಟರ್ಮಿನೇಷನ್ ಮಾಡಿದೀರಾ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ಹೌ ಇಟ್ ಹಸ್ ಬಿನ್ ಡಿಟರ್ಮಿನ್ಡ್. ಅದರ ಕೆಳಕಂಡ ತೆರಿಗೆ ವಿವರವನ್ನು ಸಲ್ಲಿಸಿದೆ.
ಹೌದು, ಅದು 2011-12 to 2015-16. That is annexure G is up to 2015-16. Annexure G may kind of look into. So the 5,64,945 out of 53 lakhs is paid. That is for subsidy.
Not paid, sir. You have determined. There is a direction to the learners involved there to determine, to quantify the amount liable to be paid by them.
Yes, correct.
For that purpose, you have determined it.
Yes.
ಈ ಕೆಳಕಂಡಂತೆ ತೆರಿಗೆ ವಿವರವನ್ನು ಸಲ್ಲಿಸಿದೆ. 2016-17 ಸಾಲಿನಿಂದ 2017-18 ಸಾಲಿನವರೆಗೆ 5 lakhs. Totally.
Correct. That is the amount included in the annexure G. Then for subsequent year ಕೂಡ ಅವರಿಗೆ ಇದು ಮಾಡಿದೀವಿ, ಅದು ಬೇರೆ ವಿಷಯ. That is entirely different. So annexure G may kindly look to 53 lakhs. It is up to that is date may kindly look into 1/7/2015. In 1/7/2015 up to 2015-16 is included. That is in the endorsement itself we said 14-15 is 31/3/2015. for the current year 2015-16 is 1 lakh so and so. Total amount is 52,73,000. So we have bifurcated. That is up to 2015-16 is included in this 52 lakhs. That is up to 11 to 12 to 2015-16 is so much of amount. Out of this 52 lakhs.
Then read further. ಹಾಗೂ ನಮೂನೆ 9-11 ಎ ಶುದ್ಧ ಚದರಡಿ.
ಹೌದು. ಒಂದಕ್ಕೆ ಒಟ್ಟು ಚದರಡಿ 27,68,000 so and so ಹೇಳಿದ್ದಕ್ಕೆ he filed an objection saying that you cannot recover this 27,68,000. Then we issued an amendment said so far this is yes, we made a mistake in the subsequent annexure which he has produced. Yes, we have made a mistake that so far as 27,68,000 notice ಅನ್ನು ಪಡೆಯಲಾಗಿದೆ ಅಷ್ಟೇ. That 14/9/2017 may kindly look into. ಈ ಕಚೇರಿ ತಮಗೆ ದಿನಾಂಕ 19/7/2012 ನೀಡಿ ನೋಟಿಸ್ ನಲ್ಲಿ ಬೇಡಿಕೆ ಇಟ್ಟಿರುವ 27,68,000 ಸಂಬಂಧಿಸಿದಂತೆ ಮಾತ್ರ ಸದರಿ ನೋಟಿಸ್ ಅನ್ನು ಹಿಂಪಡೆಯಲಾಗಿದೆ. Because that is a mistake. They should not have stated you pay 27,68,000. They should not pay for fee, for conversion fee. That made a mistake. That they have withdrawn. So other things remains in 97/2017. Then he paid the amount and for subsequent years also. Now annexure G we have clearly stated up to 2015-16. Now single judge order is from the date of sale. From the date of sale up to 2015-16, 5,64,945. And the 47 lakhs is payable. I got judgment of the Honorable Supreme Court. His liability on the transferee, it has to be, because this is all my submission.
Yes, what is your submission, official liquidator? Are you ready to pay the balance amount to make the claim? Kindly use the mic.
I am communicating with the
We can recover it from the official liquidator, sir. You can make a claim before the official liquidator and we can recover it. Now you have made it very clear. From 2011-12 to 2017-18, this is 5,64,945. And even in your subsequent letter also, that you have referred to that, and you have said that is 14/9/2017. Karnataka Ucha Nyayalada Ullekada Nirdeshanadante in complaints of the order passed by this court. ಮೇಲ್ಕಂಡ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ತೆರಿಗೆಯ ಪಾವತಿಯ ಹೊಣೆಯನ್ನು ನಿರ್ಧಾರಣೆ ಮಾಡಿ ಈ ಕಚೇರಿಯಿಂದ it has been determined, tax amount has been determined. ಈ ಕಚೇರಿಯಿಂದ ದಿನಾಂಕ 19/7/2017 ತಮಗೆ ತಿಳುವಳಿಕೆ ಪತ್ರವನ್ನು ನೀಡಿ ತಮ್ಮ ತೆರಿಗೆ ಪಾವತಿಯ ಹೊಣೆಯು 2011-12 ಸಾಲಿನಿಂದ 17-18 ಸಾಲಿನವರೆಗೆ 10,64,945 ರೂಪಾಯಿಗಳು ಹಾಗೂ ಸೆಸ್ ಮೊತ್ತ ಸೋನ್ಸೋ ಆಗಿರುತ್ತದೆ ಎಂದು ತಿಳಿಸಲಾಗಿತ್ತು. ಮುಂದುವರೆದ ಖಾತಾ ವರ್ಗಾವಣೆ ರೂಪಾಯಿಗಳು ಸೋನ್ಸೋ ಪಾವತಿ ಮಾಡುವಂತೆ ತಮಗೆ ಸೂಚಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಮತ್ತೆ ನೀವು ಅದನ್ನ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ. ಮತ್ತೆ ಮುಂದುವರೆದು ತಾವು ಈಗಾಗಲೇ ಪೂರ್ಣ ತೆರಿಗೆ ಮೊತ್ತವಾದ 14,27,126ಗಳನ್ನು ಪಾವತಿ ಮಾಡಿರುವುದರಿಂದ ಮೇಲ್ಕಂಡ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದ ಖಾತಾ ವರ್ಗಾವಣೆ ಮಾಡುವ ಸಂಬಂಧ ಈ ಕಚೇರಿ ಸಂಪರ್ಕಿಸಲು ಮುಂದಿನ ಕ್ರಮ ವಹಿಸಲಾಗುವುದು. So you are ready to transfer the khata also, because they have paid the entire amount. 14/9/2017. That has been issued after filing of the appeal. This khata
That's true. I complied with the order. My submission before the court is this judgment quashing Annex G is wrong in your Supreme Court judgment. Transfer is liable to pay the entire amount.
Yes.
He may require it from the transferor. This is
You
entirely different.
already issued the khata also. Yes. We'll make it very clear that if any claim is made before the official liquidator, the same shall be considered. Sir, you have to make it prior to confirmation of sale.
May I submit? No, may I submit, ma'am? According to Supreme Court judgment, Honorable Supreme Court judgment, transfer is liable to pay.
Yes.
If the official liquidator does not pay the amount, how can recover that amount? I have to recover from the land only, from the transfer only. That is why the Honorable Supreme Court said transfer is liable to pay. He can recover it from the transfer.
Here the official liquidator is ready to pay, sir. He's not disputing. He's ready to pay. What is required is you have to make a claim under the Companies Act. That's all. Before confirmation of sale.
No.
Kindly read section 530 of the Companies Act, sir.
May submit. If he says that he is going to pay 47 lakhs, I have no objection. I can say 53 lakhs we have claimed in that. 5 lakhs is paid. 64,000. 47 lakhs has to be paid.
47 lakhs or 30 lakhs, whatever it is prior to the sale.
Subject to the provisions of section 529A, and shall be paid in priority of all other debts, all revenue, taxes, cess, rates due from the company to the central or state government or a local authority at the relevant date and divided in Clause C of subsection A, and have become due and payable within 12 months next before that date. According to this plan, he has to pay before me.
Yes.
If it is in order, I will take permission of this honorable.
You have to file. Again, OLR ಬರ್ತಾ? ಏನು ಅದೇನು OLR ಅಂತ ಏನು ಹಾಕ್ತಿರಲ್ಲ, ಅದು ಅಫಿಷಿಯಲ್ ಲಿಕ್ವಿಡೇಟರ್.
If it is not proper, I have to say that his application is not valid or he has not given good formula. According to 530, whatever is that.
You file it, sir. Yes. Yes.
Interest of the Panchayat is protected by the other paragraph number 14 and 15.
Page 87 is the color. Yes. The Singapore Court of Appeal is directed to the Ministry of 2017 passed the learning signature in the number 26089 of 2015, where the petition filed by the respondent number 1 has been. Hello. has been disposed of. Setting aside the endorsement dated 1/7/2015, that is Annexure G, challenge therein, the respondent number 1 has been provided, has been given liberty to appear before the respondent, to appear before the PDO in the first instance on 18/7/2017, and to adduce the relevant evidence and documents before the said authority, who will pass the chance in accordance with law about the recovery of the property tax from the respondent number 1 to the extent of his liability in this regard up to the date of confirmation of sale in his favor, that is on 8/3/2012. It has been further observed by the writ court that for the recovery of the balance amount, the PDO can file his claim before the official liquidator under the provisions of the Companies Act 1956. The PDO passes it on PDO passing fresh orders in accordance with the directions of the limits of the writ court, the amounts already paid by the respondent number 1 has to be adjusted against the said fresh demand, if any. Being agreed by the said order of the London single judge, the appellant Gram Panchayat has filed this appeal. The counsel appealing for the appellant, placing reliance on the judgment of the Honorable Appellate Court, reported in 2007-8 SCC 751, submitted that the transferee is transferee of the land of the building is liable to pay the tax. There is no dispute between the local authority and the transferee. If even in terms of the sale deed or the conditions of auction sale, the transferee is, if the transferee is liable to pay the arrears of tax, if any, only from the date of the sale of the land of the building, the transferee is liable to pay and to recover it from the transferor. Climate Council has placed as referred to section 199 of the Karnataka Jilla Panchayat Act. The Karnataka Gram Swaraj and Panchayat Raj Act 1983. Climate Council appearing for the respondent number 1 has filed the endorsement dated 14/9/2017, issued by the appellant Panchayat whereby the liability of property tax for the year 2011-12 to 2017-18 in a sum of rupees 10,64,945 and cess rupees 3,62,081 totaling to rupees 14,27,026 has been determined against the respondent number 1. Withdrawing the Tata transfer fee claimed that rupees 27,68,782. It is also acknowledged the entire tax amount, entire property tax amount of rupees Purna Terige anta ide. Entire property tax of rupees 14,27,026 liable to be paid by the respondent number 1 having been received. The respondent number 1 has been called upon to seek for transfer of kata relating to the property in question. The net counsel has further submitted that pursuant to the said endorsement dated 14/9/2017, kata has been transferred on 25/9/2017 in the name of the respondent number 1 relating to the property interest. Thus, the learned counsel submits that the writ appeal does not survive for consideration and accordingly seeks for the dismissal the petition. Learned counsel for the official liquidator inviting the attention of the court to section 530 of the Companies Act 1956 and the affidavit filed before the writ court submitted but it was it was made clear that a sum of rupees 1,77,43,207 was available to the credit of the company in liquidation as on the date of filing of the affidavit, and the appellant was required to make the claim before the official liquidator for relating to the property tax liable to be paid by the company in liquidation prior to the date of prior to the date of the sale. Having considered these aspects, Learned single judge has rightly directed the PDO to meet
May I submit?
under the provisions of the Companies Act 1956.
May I submit?
As such, yes, sir.
According to judgment of Supreme Court, transfer has to pay. Let the transfer pay, and he can put for the claim before the official liquidator.
Yes, sir. As such, seeks for dismissal of the appeal para to carefully consider the other submissions relevant which is appearing for the parties and perusing the material on record. As per, it is significant to know the relevant clause of the terms and conditions of sale relating to the property in question. Clause 40 of the said terms and conditions of sale. In the matter of Machinery Manufacturers Corporation Limited in liquidation. Pending in the company petition number 41 of 19. Still it is pending, Wala? Whether it is pending as an still pending. Now answer my questions, sir. Pending in company petition number 41 of 1986. Before the Honorable High Court of Bombay reads thus, page 14, para class 40, extract mark. Indisputably, the confirmation of sale was made on 16/3/2012. Placing reliance on this document, on these terms of placing reliance on this, on the said terms and conditions of sale, the respondent number 1 has challenged the endorsement dated 1/7/2015 issued by the appellant directing whereby the said respondent was directed to pay arrears of tax till the date till 2014-15
15-16.
As till 2015-16. That is the total for the total determining the total sum of rupees 52,73,588. The said endorsement at Annexure G with the 1/7/2015 apparently does not disclose the extent of liability to pay tax by the respondent numbers 1 and 2 in terms of the terms and conditions of sale and rules 12 and 15 of the Karnataka Panchayat Raj in records Gram Panchayat Taxes and Fees Rules 1994. Read with section 199 of the Act. when a single judge placing reliance on the judgment of the Honorable Apex Court in the case of T. Vijayendra and another versus M. Subramaniam and others reported in 2007 APSC, case 751, has disposed of this writ petition observing that the liability of the vendor to pay the property tax arises only from the date of sale. Limit counsel for this has strongly placed reliance on the judgment of the Honorable Apex Court in the case of Municipal Corporation of Delhi, Supra, the question that fell for consideration in the said case relates to whether the property tax constitutes first charge upon the land or the building, and because the land or the building is fastened with this liability, the liability travels with the land or the building. This question was analyzed in the context of Section 128 of the Delhi Municipal Corporation Act, which specifically provides for the continuation of the liability of the transferor to pay property taxes even after the transfer. Still, a notice is given contemplated as per Section 128 in brackets 1. With great respect that this judgment would not come to the assistance of the appellant hearing. The property
The similar provision is there in our act also.
sold by the sold in the public auction by the official liquidator under the provisions of the company official liquidator under specific terms and conditions of sale. Next, it is significant to note that demand notice of the letter dated 19/7/2017 was issued by the appellant Gram Panchayat to the respondent number 1, quantifying the tax amount from 2011-12 to 2015-16 at rupees 5,64,945, and from 2016-17 to 2017 at rupees 5 lakh, totally amounting to rupees 10,64,945, along with cess at 34% amounting to rupees 3,62,081. Totally amounting to rupees 14,27,026. In addition to the said tax amount, an amount of rupees 27,68,782 was demanded towards data transfer cost charges. It is made clear that the said determination of the quantification was made in compliance with the order passed by this court in the petition number 306-089/2015. Subsequently, as per letter dated public endorsement dated 14/9/2017, the amount of rupees 27,68,782 claimed towards transfer of kata charges has been withdrawn, and the demand was made rupees to the extent of rupees rupees 14,27,026 towards the arrears of tax from 2011-12 to 2017-18, along with the applicable cess amount. And it has been further acknowledged that the said amount has been, the said total tax amount has been duly paid, and the kata transfer could be made by the appellant panchayat and the action could be taken for transfer of kata by the appellant panchayat. If the respondent number 2 approaches the panchayat for the same, in the said endorsement public letter, it is categorically observed that the said demand has been made after determining the tax amount in compliance with the order passed by the rich court. Further, it cannot be gainsaid that the quota of the property in question has been transferred in the name of the respondent number 1. That being the backdrop of this case on hand, the arguments made by the learned counsel for the appellant that the transferee is liable to pay the arrears of property tax and can recover the same from the transferor does not stand on a terra firma and deserves to be negated for the reasons stated herein above. In the circumstances, we do not find. Moreover, Section 530 of the Companies Act, 1956, provides the mechanism for the recovery of the balance amount from the official liquidator. This, as such, the interest of the appellant has been safeguarded by the learned single judge, reserving liberty to the appellant to file his claim before the official liquidator. We reiterate this same and next, as we do not find any merit in the writ appeal, appeal stands dismissed.
No, if the official liquidator does not pay the amount, what will happen? It is entire is gone. We can't recover it all.
No, he is ready to pay it, sir. Then you can challenge it. He is ready to pay.
Yeah, it may kindly be recorded, ma'am.
He is ready to pay, sir.
And it may kindly be recorded. It may kindly be recorded in the order.
That is after 530. That is Peripaso.
It may kindly be stated in the order. It may help us.
Within the inside, you would have withdrawn this writ appeal and you would have filed a claim. You would have made
it may kindly be stated in the order. That is my request. Otherwise,
no, what is to be stated, sir? You are always that is your right reserved.
And right, no, they may say no, there is no amount. We will not pay the amount. That's all those problems. We cannot recover. If we can recover, I can understand.
The priority on that priority basis, only preference has to be given.
It may kindly be stated in the order. It may help us. Otherwise,
sir, all these are your apprehension. That's all.
If they do not pay the amount, what I should do?
You take appropriate action, sir.
That may kindly be.
No, why
noted.
should we say so? It is always open to you. Yes.
My only request is to safeguard the interest of the appellant. One more aspect I want to say.
Yes, sir.
The Gram Panchayat became the City Municipal Council. Then I filed an application.
Yes, sir.
On Order 1, Rule 10. City Municipal Council, Hootagalli, it is there in the order. Because to continue these proceedings in the appellant as appellant. That is there in the order sheet, it is there. My application is also there. It was also allowed.
It's already, if it is allowed, then you have already amended the cost title. What remains?
No, the cost title is not amended because there is
not amended.
Illa, there is no such direction by the court. Illa. After Aglila, his permission was granted.
What is the date of the order? No, where is that application? Application for, what is that application? Order 22 rule 10.
Order 22 rule 10. May you please to grant the applicant to continue his proceedings in this appeal as appellant.
So we will allow this application. There is already an order. You have proposed that for the reasons assigned in the application, the appellant is permitted to prosecute the appeal. Application is allowed. There is already an order.
Order is there, but in the it was not.
You were already permitted. If you want to carry out any cost amendment in the cost title, carry out, sir.
Yeah, very much. That may be.
In view of the application in Rakas IU1 of 2021, allowed by this court on 21/9/2021, appellant shall carry out the amendment in the cost title. Yes. Within 14 days, you have to carry out the amendment. Otherwise, what is the purpose? Now ordering for amendment of the cost title, sir. Yes, sir.
I appear for the appellant. May I start?
Yes, sir.
So the writ appeal is against the order of the learned single judge, by which the award of the labor court was dismissed. Then the other one for enhancement of the compensation filed by the employee.
Matter was said on the last case.
Yes, we had filed some cases on point. Without question is whether a manager of a showroom, Bata showroom, is a workman or not. That is the crux of the point.
Yes.
No, similar matter, Milord, Gujarat High Court had held after considering all these things to say that he is not a workman.
You short time, no? Yes.
The respondent had short time, Milord.
Yes, sir. Argue the matter.
Yes, Milord. Now the crux of the point is this, Milord, whether the employee who was a manager of a Bata showroom is a workman or not, and entitled to the protection of the ID Act. Now, Milord, in first occasion, the labor court held that he is not a workman. Now that was challenged by him, and the matter came before this court, and this court set aside that order of the labor court and then remanded the matter back. Now after remand, we filed against that. We filed an appeal against the order of remand in WA 944 of 2007, which was dismissed, and the order of remand was upheld. Thereafter, Milord, after the matter was over, when the labor court held that he is a workman, the petition was disposed of by order dated 5/7/2011, and liberty was given to the appellant's hearing to challenge the final award passed by labor court on merits. Apart from holding that he is a workman, in lieu of reinstatement and continuity service, the labor court had awarded a lump sum of 10 lakhs. When this writ petition was filed without challenging the award, the condition was that we should deposit that amount. 10 lakhs has been deposited in court before in that writ petition, and subsequently the the employee has withdrawn that amount, and that it stands at that stage. Now, Milord, we made a submission that this matter is clearly covered by a division bench decision of the Gujarat High Court, which says that the workman, he is not a workman. The showroom manager of a showroom, he is not a workman. And that decision was cited before the Honorable Single Judge, and the SLP against that order also was dismissed by the Supreme Court. Now, unfortunately, Milord, on a totally misconstruction of the evidence and the evidence that was adduced, the Honorable Single Judge accepted that he is a workman, and therefore went on to pass an order dismissing the writ petition. And also
enhancing the compensation granted by labor code from 10 lakhs to 20 lakhs without any reason. There's no reasons given. So 2 writ petitions have been filed. Writ appeals have been filed. The WA 1362 of 2001, by which the award is accepted, and WA 1358 of 2021, by which the learned single judge enhanced the compensation to 20 lakhs. We are agreed by that. The perusal of the evidence that was adduced shows that he had administrative, supervisory, and managerial capacity. He was working. We have produced documents, and the agreement between the parties also is very clear to say that he had power to appoint temporary workmen, pay salary, and also appoint temporarily people, grant leave. These are all part of the managerial functions of the showroom person. He was managing it. Incidentally, when somebody was absent or somebody, he would also do that work, all right. But nevertheless, the main thing I have listed out a series of acts that he used to do in the course of my petition and writ appeal. And this matter essentially requires that consideration to find out whether, especially in the light of the order of the Gujarat High Court, division in Gujarat High Court, pertaining to the very same Bata company, which held that a manager of a Bata showroom is not a workman, but has a managerial capacity. And so ID Act is not applicable. That is the sum and substance. And this, of course, SLP against that was dismissed.
Yes.
Government service agreement and standing orders. In fact, the clauses in the standing orders as well as the clauses in the service agreement orders. That is not in dispute, and also the management of the data. And also after detailed comparative consideration of the standing orders as well as the service agreement clauses.
When the order was passed in the division by complete arguments, just he has given the gist of the case now. Let him argue. Sir, can you continue, sir?
Yeah. Lordship, I have listed out the acts that he used to do in my appeal memo, page 24. Page 10, page 10, there was a lot of candies.
Yes.
Contract of internal page 3, ink page 10.
Yes.
The contract of service signed between the appellant and respondent, standing order of the company for shop managers, standing order for shop employees. The following duties functions are as follows: managing and supervising, controlling the shop as per standing orders of the rules and applicable to the shop managers, discharging duties, managerial and supervisory capacity, work as independent authority in the management of the shoe store, respondent to exercise and supervisory control over the employee of the shop as well, power to appoint temporary staff. Respondent had total responsibility of stock, inventory, account, financial affairs of the shop, and was personally liable in the case of any loss, misappropriation, etc. The respondent had responsibility to take action in the event of any theft, fire, etc. at the shop premises. Respondent had the responsibility of payment of taxes and compliance with the local regulations applicable to the shop, and was also responsible for depositing cash, daily cash collection to the bank. As per standing orders and rules, the respondent directly supervised the salesman, cashier, and shop assistant. Respondent used to disperse salary, sanction of leave, and other remuneration. Respondent had the power to appoint temporary employees as well. The respondent was empowered to take disciplinary action against the employee. Now, these are some of the functions that he used to make. And he was drawing a salary of more than 6,000, which was entitled, and he was entitled to commission on the sales as per the terms and conditions of the appellant. It is pertinent to note that the nature of work performed by respondent was managerial administration and supervision. Now again, the misconduct was that it was detected that there was a shortage to the extent of 5,81,857 when they in the accounts. So obviously, yes, there was some falsification of the accounts. These are the conditions that he was performing. And all these things were in the same similar set of facts were there, performance was there in the Gujarat High Court judgment also. But somehow wrongly, the learned Singh judge has said, no, that is a different thing. No, it is not correct. It is not correct.
Where is that Gujarat High Court judge?
Yes, it is.
Chawla, na?
Yes, it is. I have produced. Last time I itself I had produced. List in the list of authorities which was produced 4/22/2022. Page one, first page.
Yes, sir.
Bata India Limited versus SK Chawla. The relevant paragraph, para 12, at page internal page 5. Here also there was a misconduct. Para 12. The question posed before us is whether the respondent appointed as a clerk and was required to do some managerial work, or he was promoted as manager and was required to do some clerical work. After going through the entire record, we must observe that if the cross-examination respondent is read with the agreement dated 12/12/1976, it would lead only to redress to the conclusion that the respondent was appointed in a managerial capacity. The courts below have not seen his statement in the documents in their true perspective and have very cursorily observed that he was coming within the sweep of the definition of workman as provided under the Act. The findings, in fact, are in ignorance of the evidence available on record and, in fact, are contrary to the records. The agreement dated 12/12/76 makes it clear the respondent is being promoted from the post of clerk to a post of shop manager. The agreement provides that the respondent was to look after all the expenses incurred for maintaining the shop. He was to take decisions regarding lighting, heating, cleaning of the establishment, small repairs which are not of permanent nature, telephone, official necessities, supplies, postage, bank charges, maintenance of satisfactory quality, and proper inventory of stock, furniture, fixtures, etc. He was also required to look after the work of window trimmings, seasonal decorations, and local advertisements. He was also to spend particular amount under the directions of the company. It is also to be seen that he was held to be responsible for proper observance, looking after the stock of shoes and other goods, including furniture, fittings, and customer as well as advertisement accessories. He was to look after the stock and dead stock and was required to clear all the dead stock under the instructions at the cost of the company. All these duties which are ascribed to him and were also discharged by him, by no stretch of imagination can it be said that to be a clerical nature. When the person is given authority to take independent decisions in a particular manner, in a particular matter, it cannot be said that he continues to be a clerical person and no independent authority to take a decision. In the present case, the respondent is appointed a managerial cadre, was assigned duties of supervision and management. In fact, was discharging the said duties. At this stage, we would like to justified and definite judgment of the Supreme Court in the matter of SK Maini versus Karana Sahu, reported in so-and-so. In the said matter, the Supreme Court observed that the terms and conditions of service whereunder the employee takes charge of the establishment would be a decisive factor. In the said matter, the said employee, by virtue of being in charge of the establishment for the principal officer in charge of management of the shop, the Supreme Court observed that the said employee was required to do some works of clerical nature, but by and large, he was in charge of the management of the shop and had been principally discharging administrative and managerial functions. Almost with the same identical situation, the present matter, under the terms and conditions of services. The respondent was asked to take charge of the establishment after the shop was put to fire, he was required to supervise the work and reconstruction and renovation. In this capacity as manager, he was sanctioned and paid. He was to look after the day-to-day management. He was to appoint temporary employees and make payment to them. Then he was required to do some clerical work, assuming it was a one-man branch. Then a shop manager would not become a clerk or a peon. The duties of a shop manager would be decided by establishment, and in particular case, in agreement at 12/12/76 clearly decides the duties assigned to the respondent. We have no hesitation to hold that the reference of the instance of respondent was not a workman, was not maintained. But
admittedly, he's also.
and he was also in the same thing. He was also as a shop manager in Bangalore, in an important brand shop in Avenue Road. These are the things that have to be considered. Now, this agreement, what is referred to in Gujarat Code, is very same, word to word same in the present case also. That also has been produced.
Standing order applicable.
Was reached finality.
Yes, Supreme Court has, yes, I have produced a copy of the SLP order also. Next page, page 8. Page 8. In the compilation.
Special petition is dismissed. Yes.
And the agreement, here also agreement is annexure A, manager of a retail store. That also has been produced. And there is a separate standing order and rules for shop managers. That also is produced, annexure B. That also is referred to in Chala's case. Both the agreements are referred to.
Now the evidence was let in, na?
Yes, yes.
The parties,
Yes.
before the labor court.
All the parties let in evidence. And it is also proved that the fact that there was defalsification of 5 lakhs 80, that also has been proved in the domestic. That is also other, apart from this. And there is no dispute that the inquiry is held fair and proper. Once the inquiry is held fair and proper, the labor court could only go into find out whether there is everything.
But here he has been promoted as a manager. Huh?
No, not manager. From shop, he was actually working as a salesman. He was promoted as a shop manager. That also is there.
Yeah.
Yes.
Shop manager.
Yes,
In the present case.
manager. Yes, he was actually appointed as a salesperson and who got promoted as the shop manager. And he was transferred to several places. Last of it was at Bangalore in Avenue Road.
So standing orders are different from Chawla's case to this case.
Yes, yes. No. Standing orders are different. Standing orders, there are two sets of standing orders. Standing orders of workmen is different. Standing orders for management is different. The standing orders that were considered in Gujarat case and our case are similar. Totally similar. 1979.
So in that case, he was first appointed as a clerk and then he was promoted as a manager.
And then he became, yes, just like in our case. In our case also, he was appointed as a salesperson. And over a course of time, he gained experience. He was made the shop manager. And different, there are different grades in shops also.
So that is the only issue involved here, no?
Yes.
Whether this
whether disqualification is there or not. 5,80,000 ರೂಪಾಯಿ ಅಕೌಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಅದು ಒಂದು ಖರ್ಚು 3 ಅಕೌಂಟ್ಸ್ ಇರುತ್ತೆ 3 copies are there. One copy what is retained it shows a different thing. The other copy sent to the branch and the regional office is different, it shows a different figure. That means he was trying to falsification of the figures. And it's all proved in inquiry. And the other strange thing is, my lord, the learned signature without giving any reasons enhances the compensation from 10 lakhs to 20 lakhs. No reasons are given. No reasons given, nothing. Only to say that 10 lakhs, I mean, enhancing it. That is all the one sentence by this learned signature.
Yes. What you say?
according to the regulations of and they will not just the reasons, precision of evidence. They will isolate, they will not just do. And they will look back.
Like, may I request my learned friend to speak into the mic? I'm not able to hear what he's saying. I think perhaps next time I should be coming to the court physically. Otherwise, it is difficult for me to follow what he's saying. Please.
Page
Page number 170.
170. Yes. Lecture H is referring to. Yes. Yes, sir. Yes, sir.
Based on the pleading, parties with the subject matter of claims and following one additional issue. Whether the first party is not a workman as highlighted by the second party of the council. Management of quite a one of the and my criticism is always by authoritative on the issue regarding presence of domestic inquiry. My criticism is always by authoritative in 2004 regarding presence of
Reading the claims.
and thereby called on the second party management to give evidence on other issues including the order dated 16/9/2000 passed by the criticism office on A1 came to be challenged by the bank. By way of repetition number 4, the second repetition came to be dismissed by order dated 50 affirming the order of this court to consider the actual issue of all other issues. Accordingly, both parties left oral and documentary evidence in the passed an award by order dated for voting action issue with the affirmative against the first party. As against the award transfer and what is by order dated to the resolution thereby award dated to the matter came to be removed back to this court by fixing the limit of and the question as whether workman other petitions are workman or not, and the court comes to the conclusion that petition is workman, then it should proceed further on the right. And in case labor court comes to the conclusion that it is not a workman, no need to proceed further. For better appreciation, the relevant portion of the order varied petition to include the second. Accordingly, the petition is award dated 1 and the petition is workman or not, considering the actual nature of the work carried out. In conformance with the clauses of the standing orders and the appointment order, thereafter, if the labor court comes to the conclusion that the petition is workman, it should proceed further on the right. In case the labor court comes to the conclusion that it is not a workman, no need to proceed. First party to put it the right to set aside the order and the order of the order will not be it is made clear that all the contentions related to the and the parties shall also be
Now come to the reasons at page 175. Continue.
Learners also for second party management in support of the argument as clear about the problems, including the estate owners cases. But after the learner also for the first party advocate in support of the argument as clear about the decision of now I just thought the observation made that in the decision that we know, the learner concept of the second party and one preferred by the learner by the second. I am to observe that the lodging, the case court status of open and then for regular appreciation and effective. He said he very good. The court adopted pragmatic and not a pragmatic. What the court has to see is what is the preliminary or substantial duty which person is performing. Does this at work is managerial, administrative, or supervisory? What is the remuneration for? Then to consider which side of the line they fall, labor or management, and then to consider whether there are any reasons for moving them over from one side to another. In arriving at conclusion, the nomenclature attached to the designation should not blur the line. Similarly, some additional or incidental duties attached to labor should not be given undue limitation. Substantial duty performed by the person to be gathered from the terms of job performance. Terms of contract, equipment revenue, also from old revenues, and cultural material that would be to the layout. Any one of them is not necessary. It is a question of fact. Therefore, it is cumulative effect of all the material places, but which should be made the basis for finding on whether it is a work and not. So also the lordships in Mrs. Pan working as case records of that mere nomenclature of salary is not criteria versus the nature of the work of that employee. As to whether he is a workman or not, and on the other hand, the same should be determined with reference to the nature of the English performance. That such question has to be determined with reference to the fact of the person. And the nature of the court is not possible to make out a straight which can decide that the real nature of duty is going to be performed by an employee in all cases. Admittedly, parties to the proceedings are both the standing order of the year 1979. So marked exhibit M9 and M9, 28 and M9, and also the service agreement. So marked
So in Chawla's case, also standing orders of 1979 was applicable.
Because there are different standing orders. Here it is for shop managers. So if I were to take the voting shoes, and there are different managers, district manager, personal manager, administrative manager, and all these managers, so people different requirements. Our only primary business is vending footwear. In shop. Vending footwear, and the merchandise that is manufactured by the company. They issue circulars, instructions, prices, products. There are various types of shops. So when I was terminated from the service, not an avenue or job, it was a less type shop. There are different grades of shops. So far as the vending product business. There were at that point of time, I was putting 20 years of service.
He had never disclosed.
Only the nomenclature was I was named as a manager. Preliminary duty and primary duty was to bring and keep accounts, we will keep the fees, keep the premises clean, and whatever guidelines that they issued from time to time, by the superiors. Except for that, nothing. Apart from that, I don't have any other powers as the other thing that also pointed out in the first instance, what are the things that are.
Yes.
And this, that part of the aspect has been discussed in this class. Admittedly,
Lord, what I would suggest is, Lord, this, I am not able to hear what my learned friend is arguing. It is echoing, and I don't know what paper he is referring to, which paper book, which
It is page 177, sir. If it is not audible, you can come to the court physically. He's using the mic and he's reading this page 177 and page para 70.
Admittedly, in the case where the first party applicant joined the second party management at the same time to work in the sales complex in the year 1973. And the regulation 26 finds a place at MA deserves to be reviewed. It is also given that under clause 8 of the standing order, the first party applicant came to be promoted as a sales manager in the year 1984 until 31/10/1984, he was working as a sales manager. It is also not in dispute that till 31/1/1994, the date on which the first party was he was a member of the managers union as can be seen to the exhibit W6. all the transactions that take place in the retail outlet showroom of the second party management are concerned to sales only. And as such, each and every staff attached to the retail outlet showroom should put his efforts to see that sales are boosted and provide incentives to each of the staff depending on the sales done. As rightly pointed out by the learned counsel for the first party applicant and also the concern and conceded by the learned counsel for the second party. And when standing orders with the subject matter of exhibit M9 and terms and conditions of the agreement that can be named are almost one and the same. And also they consider this aspect. This is not a dispute. Paragraph number 19. In the management law. Paragraph number 19.
Yes, sir.
As rightly pointed out by the learned counsel for the first party applicant and also conceded by the learned counsel for the second party management, standing orders which are subject matter of exhibit M9 and terms and conditions of the agreement at M28 are almost one and the same and demonstrate the same. The learned counsel for the first party applicant took attention of the court to para 3 and 4 of exhibit M28 being a similar clause 15 of the exhibit M8. Clause 1 of M29 is similar to order 11 of exhibit M8. Clause 1D of exhibit M29 is written to order of that comparison is done. Even this aspect of the matter was also appreciated by the learned signatures. Clause 20. Now, the standing orders refers to general duties of an employee, a part-time director, and these aspects make it crystal clear that in addition to regular duties of the sales plan, employees are expected to do other duties. In that way, terms and conditions of the service agreement at exhibit M29 stand par with class 17 of the standing orders pertaining to officers. In this regard, MW reports to AFR, who is presently working as the manager of water solutions situated at Kodi Hospital. Bangalore plays an important role, and he has narrated in detail at paragraph of the agreement as to what are his duties and the shop manager, and in what way duties of the shop managers differs from duties of other staff attached to the MW4 IFA has been subjected to lengthy cross-examination by the London Council for the first party, wherein it has been elicited that employees of the second party management are expected to discharge duties to entrusted to them, as mentioned in the standing orders, at several levels like personnel and administration, sales, area manager, district.
So against this additional issue, this repetition has been filed. Against this order on additional issue, this repetition is filed.
Entire thing was and whether the order of this court was giving liberty to challenge the final award after if it is on merits, that is also annexure N is what the order that gave liberty to challenge the findings of the labor court on merits also. Annexure by this court order passed by the on 5/7/2011. This court passed an order giving liberty to challenge that. To produce annexure N.
Petition has been dismissed in the earlier round. Yes. On the challenge made against this issue.
Can I have a look at the annexure N, Miller? Page 388. You will get it in the other connected in 1362, volume 2. The main petition is 1362, my lord, where we challenge the finding of the labor court that he is a workman. The other one is merely an enhancement of compensation, that's it. That was Malena was referring to the other appeal, which was filed against enhancement. Your Lordship may kindly have a look at annexure N, page 388 in the paper book number 1362, volume 2. At page 390. In the instant case, the petitioner has called in question the finding recorded by labor court on the preliminary issue relating to the status of the employee as to whether he is a workman or not. against the petitioner. Hence, this in the light of the aforesaid report of so I decline to interfere, reserving liberty to petitioner to question the said finding and order if aggrieved by the final outcome of on the merits of the industrial dispute in an appropriate legal proceeding, petition is rejected. So there was a liberty given to me to challenge the final award if it finding went against me, which we have done it in the writ petition again, which is impugned in the order which is impugned for your lordship.
Yes, sir. Yes. No, you need not read it. We have seen it. Come to the next point.
Towards the end of the book,
All these are heard like first appeal, like we are hearing the RFA. Chief examination, cross examination. Yes. Yes, sir.
Be admitted and some date may be fixed for hearing. Paper books are there, voluminous papers are there. Any convenient date may be fixed for final arguments. There is no difficulty. And we have complied with the order of the tribunal, my lord, which said give him 10 lakhs. That has been deposited in court. He has withdrawn that amount also. So whatever.
Oh, yes. You are arguing only for admission, huh?
Yes, my lord. How though? Admission ke bandiro the case.
Then you will admit the matter.
Please.
So far as this thing is an amount and is concerned, that's already ordered.
In just the argument is the final arguments are if he succeeds. And then if your loss is up,
10 lakhs has been.
deposits in court. Also, an application was made and he has withdrawn it also.
So both of you argue like this, it's very difficult for us to understand. Yes. 7.5 lakhs rupees was.
And during the pendency of the petition, the lot again, another 2.5 lakhs already available. So total 10 lakhs was available. And also the registry was directed to keep the money in the FD. And that was the position. And later on, after disposal of the petition, without releasing the interest amount, only the 10 lakhs amount was directed to the school. And the other amount is still lying with it.
The interest amount.
There is no other amount. 10 lakhs is what is ordered by the labor court, and that has been deposited here.
The learner single just announced it from 10 lakhs.
And that too, we are saying that if you don't pay in terms of 12% interest. 12% interest, yaar kodtare in Kaldali. It's all in the Kalatile. Now you can't expect 12% interest on all these amounts. 6%
interference. If there is no reason assigned for announcing it from 10 lakhs to 20 lakhs.
There is no reason given. There is no reason given. Just one line.
1994.
Correct. There, where does it get the reasons? You have produced, but the order. Yes. Yeah. That reasoning is not forthcoming. Why it has been announced from 10 lakhs to 20 lakhs?
Kindly have a look at page 50. 1362 volume 1.
Labor code is not going to
So now we have to give the reasons why it has announced from 10 lakhs to 20 lakhs. We have to give the reasons. Yes, we will admit the matter. Admit. Interim order did not come in the. Now he is working,
In lieu of reinstatement, without compensation is given 10 lakhs, which is deposited in court. The grievance by learned friend can have on that point.
No, what is your submission? How you have to safeguard your interest? No, we are not passing any interim order. You already the 10 lakh rupees has been deposited and you have withdrawn that amount also. What interim order is required? This will admit the matter. Let him come for final hearing in the usual court.
Please. And 10 lakhs, so for the 10 lakhs is concerned, now interest ಕೊಡಬೇಕು ಅಂತ ಮಾಡ್ಯಾರ. ಅದು that kindly, that portion of it, your lordship may kindly say 18% interest ಕೇಳ್ತಾ ಇದ್ದಾರೆ. If I don't pay within 4 weeks, court has ordered a payment of 18% interest. It's unheard of.
Now, which portion of the order requires state?
52, page 51, operative portion.
Yes.
Yes. So far as impugned order is concerned, compensation stands modified. The petitioners also is entitled for compensation in the sum of 20 lakhs instead of 10 lakhs as awarded by the Labour Court. That is one thing. Second one, 5. If compensation as directed by this court is not paid within 4 weeks, the management is liable to pay compensation along with interest calculated at 18%. This is usurious interest in the present times now. 18% interest calculated from the date of last payment as directed here.
Class 5 of this order has to be stayed. 5, class 5. Only the interest part we will stay because for the for the remaining amount of the cost.
20 lakhs ಇದೆ, ಅದನ್ನ 10 lakh ಕೊಟ್ಟಾಗಿದೆ. You enhance 3 also. Para 3 also has to be stayed. More and above 10 lakhs. So 10 ಲಕ್ಷ 20 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದಲ್ಲದೆ ಇಂಟ್ರೆಸ್ಟ್ 18% ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
Order of a single judge. Alla, similarly. What is the interim order you have sought for?
Stay of the award of order of the learned single judge.
Entire order.
Insofar as it relates to award of compensation. Modification. So far as Lord, what I submit is this: that entire amount ordered by Labour Court has been deposited in court and is withdrawn. Now, stay can only be in tune with the order of enhancement. That is all, and the stay of interim stay of interest. So, why we are challenging is this: supposing it is held that a shop manager is a workman, it has pan-India effect. There are thousands of showrooms in all over the country, and everybody, if there is a manager who says, "No, I am a workman," and then start raising dispute, there is no end to it. That is the complication that arises in this regard. So we had to file a writ appeal challenging in the order to say the shop manager is a workman or not. That is a matter in the light of the Gujarat High Court decision.
The operation and execution of the order dated 21/10/2021 passed by the learned petition number 41805 of 2004 is stayed in so far as payment of rupees 20 lakhs instead of rupees 10 lakhs. Stayed as directed by the court to take the payment of rupees 20 lakhs instead of rupees 10 lakhs, and If the said amount is not paid within 4 weeks, the management should be liable to pay the compensation along with interest calculated at 18% per annum from the last date for payment till the payment is actually made as directed by the London Single Judge. No, that is, it is to pay the, at least you pay some amount subject to some, at least deposit some amount, sir.
10 lakhs is deposited, my lord. That is the order of the. While the
10
petition, 10 lakhs was deposited.
10 lakhs, there is no dispute.
That is withdrawn by him, my lord. That is withdrawn by him. 10 lakhs is withdrawn by him.
At least you deposit some amount now.
My lord, I said, that is why I said, my lord, the matter can be heard and then once and for all disposed of.
Yes, we are ready to hear.
Difficulty is, supposing I succeed in the appeal, how do I pursue him to get back the money?
Yes.
That is also there. Entire amount is whatever that is there.
We will not, now we will not permit him to withdraw. It's deposit some amount at least.
We have already withdrawn it.
Yes, sir, at least some amount. The interest part we can stay, not this 10 lakhs.
That whatever accrued interest, my lord, the deposited before this honorable court, my lord, that he must have, I don't know, I'm not very sure. He must have withdrawn that amount also, 10 lakhs plus the interest, he must have withdrawn. I am not very sure. 12-year interest for 12 years.
No, if we, at least we can direct you to deposit the interest at least for the 6% per annum as directed by the labor code that has to be calculated. But we have to calculate all that is here. So instead of that, one lump sum amount we deposit it.
We deposited 10 lakhs. 10 lakhs has been, as my lord, when this appeal writ petition was argued.
That there is an earlier order granting interim order.
Yes.
No.
This order, the court directed me to deposit 10 lakhs. That is the full award amount. The compensation to be paid to the employee. That a full amount has been paid and he has withdrawn. And 6% interest is being accrued from past 12 years. And 6% interest on that is being getting accrued on that amount. And he has withdrawn.
The query is about interim order, earlier interim order in writ appeal, not in writ petition.
No, writ petition, my lord. Writ petition. Writ petition only. Then on the appeal. Petition only again.
In the writ appeal, is there any interim order?
No, nothing. First time it is coming up before your lordship for admission. No order.
So you deposit this amount at least. Then we will say only this portion of the interest amount, because up to that extent 6% interest as directed by the labor code is entitled to on that amount 10 lakhs. So deposited 10 lakhs.
Lordship, my lord, if it can be considered, I'll deposit 5 lakhs, my lord. I'll deposit 5 lakhs, subject to result of repression. He being to withdraw the amount. Let it lie. If he wins, if he succeeds in the, let him take that. It's subject to your lordship's interference.
Sir, businessman. Sure. Yes. This we will say that only this class 5 will be stayed. In the 3 everybody, is stayed only the order of the London Single so is stayed only as far as class 5 is concerned.
Enhancement, my lord, there is absolutely no iota of reasoning for enhancing it from 10 lakhs to 20 lakhs, my lord. The lordship saw the order.
We will not allow him to withdraw. The appellant shall deposit rupees 10 lakhs. Before this court, within a period of 2 weeks or 4 weeks. 2 weeks.
4 weeks. Adu 3 weeks ಮಾಡಿ ಅಷ್ಟೇ 3 weeks.
ಅದರಲ್ಲಿ ಹಾಕೊಂಬಿಡಿ. This is class 5 is state subject to the appellant depositing rupees 10 lakhs within a period of 3 weeks before this court. On such deposit, the said amount registry shall invest the said amount in an interest bearing fixed deposit till the final disposal of the appeal.
Then, my lord, if that is deposited, there is nothing much that really survives in the appeal. The entire that it has to be stayed. Entire impugned order has to be stayed, my lord. Because whole amount is dispersed. So far as the enhancement is concerned, the whole
Not
amount
disbursed, only 10 lakh rupees has been disbursed. This amount will be in the
10 lakh already deposit ಮಾಡಿ ತಗೊಂಡ್ಬಿಟ್ಟು ಅದು withdraw ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದಾವೆ. Yes, the whatever compensation.
now permit him to withdraw this 10 lakh rupees.
So the entire 20 lakhs sound ಗೊತ್ತಾಗುತ್ತದು. That is a difficulty.
No, we are not permitting him to withdraw this 10 lakhs, sir.
Please.
Let it be in the court deposit. Let it be invested in a fixed deposit by the registry.
Subject. Then in which event, my lord, the entire order has to be stayed in total. Because 20 lakhs is what was ordered by the learned single judge. Now the entire amount that comes now before your lordship, it is now there. 10 lakhs is already dispersed. Other 10 lakhs is there, which is in deposit. And
that is not required to be stayed at all now.
It will not be permitted to withdraw. I quite understand that.
No, that's if you have already paid 20 lakhs, no, by 10 lakh rupees already been paid and that has been withdrawn. Another 10 lakh rupees we are directing to deposit. Then nothing remains for you to pay regarding the 20 lakhs. Now the dispute would be only with regard to 18% of interest.
That is exactly my submission is, my lord, that if 10 lakhs is paid, nothing much survives. So what I would suggest is, let the matter be heard on merits on this point, whether the court was.
We are ready to hear you, sir. We are ready to hear you.
Please, my lord. Then I'll deposit this 10 lakhs, my lord, in 3 weeks' time, subject to making it clear that he is not entitled to withdraw the amount. Let it lie in the court.
Yes, we have directed the registry to withdraw, to deposit in an interest-bearing amount till the final disposal of this writ appeal.
Please.
Yes. Muttanna? Yes. Canara Bank.
Initially, he joined the services of the response back in 1973. Thereafter, in 2006, but he earned various promotions from grade 1 to grade 4. From 12 to grade 1, then to grade 2, then grade 3, and grade 4. In 2006, he was mostly working Puttur branch lord of the bank. But while working in the Puttur branch, there was a show cause notice for which the appellant replied, and then the charge sheet for which the appellant replied. Now, the gist of the charges as against the appellant is that there were two customers of the bank. One was Mr. Vestamji Isa, and the other was Vivekananda Vidya. As per the instructions of the customers, an amount of rupees 50 lakh was transferred from the account of Mrs. Vidya Vivekananda to the account of Mr. Isa. But this was done on a particular day, that is on 1/1/2009. And later, we learned that amount was to be transferred to the account of Vidya. So the only allegation against the appellant is that this transaction you have done to accommodate Mr. Vestoji Isaac. Only to prevent the account from slipping into NPA. Because he had an agricultural with the bank, that is KCCS. You have done this transaction only to accommodate it. It is you who have done this transaction. And there was no instructions for the customers. Please do not charge against you. Now, this has been held proved by the inquiry officer. I take a lordship note how it is exactly contrary to the evidence on the court. Very few evidence, not MW1 and MW2 are examined. One is the investigating officer, other is the officer of the bank. MW1, except identifying some of the exhibits, there is absolutely no evidence that is available. MW2 will not speak about his investigation reports. Those two investigation reports are done. And then there is a clear question to MW2. Question is that as to whether it was done on the instructions of the customers. He answers it as yes, and then that he was working as a chief manager. There is no request from the chief manager to do this transaction. Now the inquiry officer holds diametrically, findings are diametrically opposed to this particular, admission on the court. So therefore, we are there. Though he holds it as true, ultimately, the inquiry officer himself states in the inquiry report that there was no malafide intention by the petitioner. It was a genuine transaction that has taken place. But he has done it to accommodate the Vestoji Isaac, and according to his instructions, these things were carried out. Now, this is the ultimate finding where the inquiry officer himself says that there is no malafide intention or there is no.
Now, what is the penalty for dismissal?
Penalty is mentioned in there. Section G, senior management takes a 4. 2 the middle management takes a 3. It is a major penalty. Next to only to remove. After dismissal removal, then compulsory next is without this section is there. It is virtually civil debt because the pensionary benefits, the pay that he receives gets substantially reduced. Even after now he is retired. Even after retirement, the pension amount that he gets is not enough to feed his the regular normal like that. That will not be the impact on the financial benefits. There will be a lot of the record. Now the charge sheet will not be the connection C and page 60. Page 60. Yes, the charge sheet connection C. Articles of charge. Both paragraphs are exactly. Vestoji Isaac is a customer of 2 sanctions. You are granted KCCS limit of 60 lakhs on 19th of 2006. You could not clear the limits by the end of December 2008 due to recession in the other market. Since there was no time for it to raise for such.
We'll take up this matter day after tomorrow or by next week. Day after tomorrow. With this matter. ಮುಗಿಸಲ್ಲ 34 ಏನಿದೆ ಹೇಗೆ 33 correct 33 what is this land reforms
You are appearing for the appellant in the connected matter, my lords. My lords, notice has to be issued to the respondents, my lords.
non-furnishing of translated copies of annexes.
My lords, I have already filed IA for dispensation of the translated copy, my lords. That has not been put up.
The connected matter, there is IA is not available. The production of translated copies of annexes is dispensed with the present. Then in this matter, in the connected matter, notice has to be issued to the contesting respondents, private respondents.
Yes, my lords. Respondent number 1 and 4 is by AGA, my lords.
Then the others may be already served in the connected matter.
My lords, respondent number 2 and 5 are served on the connected matter, my lords.
Anyone representing them?
Yes, my lords.
Sharada S. Shetty. R1
No,
to
my lords.
R5.
I am representing them. Sharada Shetty is my colleague, my lords. The appellants in the connected matters are the respondent number 2 and 5 in this matter, my lords.
And Sukumar Jain.
Yes, my lords.
We will direct him to accept the notice.
Yes, my lords. For respondent number 3, my lords, notice has to be issued, my lords. Since she is not a party in the other matter.
Now, this is Aruna and Vishala in Negade. They are who are the appellants in connected matter?
In the connected, my lords, Indira and B. Niranjan, my lords.
Saraswati, deceased by LRs. Vishal in Negade. Learned counsel Sri N. Sukumar Jain is permitted to accept notice of respondents 1 and 2 in the connected matter.
Respondent 2 and 5, my lords.
Respondent numbers 2
and 5.
2 and 5.
Yes, my lords.
2 and 5. 5 is Sharat Chandra Ballal.
No, my lords. In my connected matters, my lords,
878. 5
yes,
is Sharat Chandra Ballal, sir.
No, my lords.
Correct agide one. This is 878 is filed by Saraswati.
My lord, Sharat Chandra Ballal is the appellant number 5, my lords. State of Karnataka is the respondent number 1, my lords.
878 Sri Indira Leela Adishwara Swami Basadi.
Yes, my lords.
Indira is the party in this connected matter.
Yes, my lords.
Leela is also not there.
So for Srimati Leela, my lords, notice has to be issued.
Only for 2. Sukumar Jain is permitted to accept notice for R2. Issue notice. Learned AG accepts notice for respondents 1 and 2. Issue notice to the other respondents. Why they are not parties in the connected matter?
My lords, that was pertaining to other properties, my lords.
Yes. To take out notice to the others.
Yes, my lords.
This matter, my lord. Lordship may kindly, yes, my lord. This may kindly taken up on some other day, my lord. Because some incompleted papers are there in file, my lord. It may kindly taken up some other day in the next week.
Week after next.
I am for the contesting respondent number 1, my lord. My salaries, my lord, are. I am for the contesting respondent number 1. Lord, my salary, I have superannuated, retired also from service. But by virtue of the order pass,
is expressing his.
Yes. I will try to, my lord, give. I will try to give one set of entire writ petition papers to my learned friend.
That would be better.
Would your lordship have it someday on Wednesday, Thursday, my lord, if it is convenient to your lordship?
No,
It is in final hearing.
If you furnish the copies, we will have it by next week.
Grateful.
My lords, I appear for the appellants in this case, my lords. My lords, there is nothing pending in this matter, my lords. The matter will have to be heard. My lords, it will take some time, my lords. Sometime next week, my lords, if this can be taken up.
Yes, week after next, yes.
My lords, obliged.
Mali Patil, Mr. Mali Patil.
My lords, I am here, my lords.
Yes. Yes, what is the matter? Whether the matter survives or considered?
Yes, my lords. Yes, my lords. Because there has been a stay, my lords. Some of the students are wanting to, my lords, for the results to be announced, my lords, with respect to their first attempt itself. My lords, tomorrow, my lords, or on Monday, or on Wednesday, my lords, I'll be able to address.
Next week.
My lords, Monday, my lords.
No, next week it will be listed. Interim order, no. Week after next. Week after next. Where is Mr. Raghupati? Kanya Council, Mr. Raghupati. No, let the other side be present. In his absence, it's not proper for us to grant any interim order. It will be listed by next week then. It will be listed. Let it be listed by next week. Yes. Huh? Look after next. Interim order retaining stands extended to the next week of